Your call. Meeting called to order.
For roll call, Holland.
Present.
Kaplan. Lemaire.
Here.
Lucas.
Here.
Miles.
Here.
Miller. And Wyman. You have a quorum.
Okay. And so I came to speak this evening really in anticipation in most part of the study session, because I was told that I wouldn't have an opportunity to speak during the study session. And as those of you who know me, that doesn't slow me down too much. So first of all, I do want to make a comment, because we're study sessions on the master plan. And I do want to make a comment on one of the subjects tonight, which is the trail that is being proposed to be vacated. I would like to remind Planning and Zoning that one of the goals of the master plan is to preserve the existing village trail system and to design and pursue opportunities to enhance and expand the trail system that are practically and economically achievable. Number 7, under the master plan in that category, is identify land and funding sources in order to improve and expand the trail system and enhance wildlife habitat within the trail system. Would like you to keep those things in mind, because nowhere in the master plan is there a public desire to reduce the trail system. And thus I would ask that what can be done in a vacation that would enhance and expand the trail system. I don't know what that is, but if it doesn't do that, it shouldn't be done. Now, the other thing I want to talk about is the master plan update, the community survey. I am very, very concerned that this survey is very biased to get responses that it may want. Now, I am not saying that anybody wrote an intentionally biased survey. If you know about the science of surveys, it is extremely difficult to write an unbiased survey. And you really need experts to do it. You need people who are not actually involved in the process, because they will inadvertently bias a survey. And I'm going to give you an example in our survey. The first question, the second question. Which aspects of the community's character do you feel are important to Cherry Hills, blah, blah, blah. 1, moving overhead utilities underground, comma, to enhance visual character. Okay, the next one, character of local streets. What does that even mean? Character of fencing. What does that mean? Ensuring regulations preserve dark areas, prevent light pollution in the community. Preserving open space and or view corridors in the community. Historic properties and resources, period. The only one that has a positive description in it is moving overhead utilities underground to enhance visual character. It's not only the first question, which we already know in a survey will get a preference, but it also has a positive description to it. I might have said moving overhead utilities underground regardless of cost. See, that would have gotten a different response from people. Historic properties and resources, nothing on there. What if you said historic properties and resources to serve as an educational asset to our children? That would have gotten a different response. I'm not saying you should do that. I'm saying that you can easily and unintentionally create biases that then impact really what this community wants. You put children in behind something, people are going to check it off. If you put unlimited costs, they're going to say, no, I don't want to do that. And this continues throughout. And the two that I actually checked with people on, three things. One was the roundabout. People almost had heart failure. Why in the world is the roundabout in the survey? And the other one was stadium lights at schools. And I mean, I don't know why they're in there. And I know that if you want a reaction that is out of proportion to what you think the question is, you will get it. And that's not what you want. We want this process to be a good process and a positive process. And if you want to do a survey, and I would caution against it, because it really is very difficult to do an unbiased survey, no matter how hard you try, unless you get somebody who's an expert at that. I would just say, you know, let's really look at this master plan process, and I know you guys are very serious about it. I know a lot of you know it very well. And, you know, I think we can do it without a survey. But if you're going to do a survey, I would suggest that you do it at the end of the public information process, so that people can have asked their questions, have a better understanding of what you're talking about, and then you go out to the public and you survey them based on what you've learned in the public open houses and et cetera. It will also prevent the really knee-jerk reaction you're going to get from some people in this community who have very loud voices, and perhaps those voices are good and perhaps they're not, but it may drown out some other people, and I'd rather see a more friendly process. Thank you very much.
Let me ask you a question if I could.
Sure.
Are there others on the Citizens Advisory Task Force that feel the same way? And if so, how many would you say?
Okay. I'm going to tell you a little bit about our first task force meeting. That's the first time any of us got to see the survey at the meeting. So we had a little bit of discussion. It got cut off because after an hour it got cut off. So we have not had any discussion. That's all I can tell you, Mike. We haven't talked about it.
So I was at that meeting also, and I share some of your concerns. We did ask people, I think there were 20 people there probably, to provide written comments regarding the survey. And we had one non-planning and zoning member comment, which was you, and thank you for sending in your comments, but I'm a little concerned as to why other concerned people didn't send written comments in.
Well, I don't know, Mike. It might be, I mean, I wasn't permitted to give this presentation to the committee to see what their response would be.
Right.
So they might be concerned. Also, when we were to give written comments, we were told to keep them, to limit them. So I gave you 2 written comments. One was on the phrasing of the roundabout and stadium lights. And those comments actually came from community members when I showed it to them. And then my other one was on open space.
Okay.
So, I mean, we haven't had the discussion.
Right, okay. Well, we appreciate your comments this evening and your written comments. We have a work session at the end here. I don't know if you feel like staying around for it. You're
No,
welcome to.
I am staying. I was told that public comment was not permitted at that. And so that's why I'm jumping up now.
Great, okay,
So,
thanks. We look forward to your
Sorry.
continued participation.
Commissioner Lemire, just a point of clarification. It's the Planning and Zoning Commission's purview to whether or not they will allow public comment during your work sessions. It customarily hasn't occurred, but it's certainly a matter for Planning and Zoning Commission if you so choose to allow it.
Okay, thank you.
And one more point of clarification. I believe that, and Ethan, you may have more details. I don't have the specific details. An early version of the survey was mailed out to CAT members for feedback. That's back when we were locked down and there were no in-person meetings. But there was some early outreach to CAT about the survey with an opportunity to provide feedback. We did receive comments, I think, from CAT members, including Laura, but I think it was like 3 folks that we heard back from. I think but that's off the top of my head, don't quote me on that. So, you know, I just want to make sure that we understand there's no effort on behalf of the P&Z to somehow cut out participation from the CAT members.
Thank you. Anybody else from the audience? Okay, so we'll move on to number 5, consent agenda. Approval of minutes for the meetings of June 23rd, July 14th, September 8th, June, and those are all 2020, and then June of 2021. And have we just not approved these before because we haven't been in meetings, or?
Yeah, so per COVID, we're catching up on approval of
Okay.
minutes and then signing and formalizing them.
Gotcha. Anybody have any comments? Okay, I'd move for an approval. All in favor?
Second.
Sorry.
Are we doing them one at a time, or can we do them all together?
We can do them all
It's a
together. I
consent
think.
agenda, yeah, so we can just do them, right?
Moved and seconded, all in favor? Aye. Number 6, new business. Vacation of the city's interest in the bridle path easements on 2 and 4 Canito Lane. Jay Goldie presenting.
Good evening, Chair Lemire and members of the Commission. Before you this evening is an application from the Theory O'Leary Living Trust requesting vacation of the city's interest, if any, in the bridle paths on 2 and 4 Canito Lane. I will keep my overview brief and then ask the applicant to make their presentation. City Council considered a preliminary petition for vacating these easements depicted on the plats that you can see on your screens for 2 and 4 Canito at their regular August 18th, 2020 meeting. At that meeting, Council determined that the preliminary petition possessed sufficient merit to justify further consideration and authorize the further processing of a formal petition for vacation. On April 8th of this year, PTRC held a public meeting concerning this request. The Parks and Trails Commission made a recommendation to deny the request. These minutes are in your packet of their discussion on that. This public meeting in front of Planning and Zoning is the second step of the formal process. The applicant is seeking a formalized vacation of the city's interest, if any, in these easements in an effort to remove any encumbrances that may create ambiguity on the title of these properties. The city has never maintained or improved these bridle path easements, and they have not been placed on the Parks and Trails map. The trails are currently inaccessible due to geography and lack of connectivity to other public trails or rights-of-way. There are other alternate trails that exist in the vicinity that provide access from Holly Street to the Highline Canal. The next steps in the process, staff will take the recommendation of the Planning and Zoning Commission and PTRC to City Council for a final determination at a public hearing. At this time, staff is recommending that Planning and Zoning make a recommendation to City Council to vacate the city's interest, if any, in these trails. Excuse me. Please remember, you have also received under separate header a confidential memo from the city attorney. So you have that also as your background information for this. So at this time, the applicant will make a presentation on their request, and I will turn it over to Amy Brima, the representative for the applicant, to make that presentation.
Thank you, Mr. Rowley.
Hi, thank you. I just want to make sure everyone can hear me okay? Okay. Commissioners, thank you very much for your time tonight. My name is Amy Brima, and I represent the applicant, the Theory O'Leary Trust, in this process. I would like to thank Jay Goldie and everyone at the city for their presentation and support of the application. I have been working with Denise and Kent since 2017 on a settlement solution with Cherry Hills Village related to the private bridle path easements that are the subject of this vacation request. We present now to you tonight our request to vacate. The Theory O'Leary Trust requests vacation of any interest Cherry Hills Village claims in the bridle trail easements shown on the map, pursuant to the Cherry Hills Municipal Code. There is no request to vacate the private easements as shown on the plat map. The existing plat maps will not be modified. There are two pictures of the area requested to vacate. The first one is the one that Mr. Goldie just showed to you. This was prepared by the city and was included in the official notices that we are required to provide in advance of these meetings. This depiction was prepared as part of our application by a licensed surveyor and shows the exact boundaries of the requested area that we are requesting to vacate. It's a little faint, but you can see the shaded areas are the easement areas that we are requesting be granted in this vacation process. First, as you can see in your packet, there is broad community support for the vacation of these easements. The citizens of Cherry Hills Village have submitted numerous letters of support for the vacation of the 2 and 4 Cantato easements. All letters that have been submitted are voiced support. Not a single citizen submitted a letter in opposition of the vacation of these 2 easements. The standard of your review is the best interest of the community for Cherry Hills Village, and we are asking that this be served by granting the petition for the vacation of the 2 and 4 easements. Second, the vacation supports the priorities of the Cherry Hills Village community. The standard of review, as I stated, is the best interest of the city. Stability of land ownership is in the best interest of all citizens of Cherry Hills Village. It is really complicated for people when they have clouds and encumbrances that may or may not be on their title related to items that are not in the public record. It benefits no community members to make claims to easements that are not based upon real property records or historical use. Another criteria for you to consider is that there are no future benefits that benefit the city or the citizens of Cherry Hills Village that are being denied by granting the vacation. For example, there is no job creation or public services that are being created or taken away. Rather, supporting this eliminates costs, particularly costs of litigation. Denying the petition would not address any community concerns. However, granting the petition does address community concerns as noted in the numerous letters of support that are in your packet. From a cost-benefit analysis, the 2 and 4 Cantato easements are not used by the public, so there is no benefit to Cherry Hills Village to go through the litigation process again in an attempt to obtain them. The Arapahoe District Court determined in previous litigation that similar easements in Cantato were in fact not public easements. The district court judge granted the plaintiff's request for declaratory judgment and a motion for summary judgment that the Cantato easements at issue were private, the easements were not public. Specifically, the judge ruled the city has not met its burden of persuasion on the original owner's unequivocal intent through formal documentation or their affirmative specific action to dedicate the bridle paths to the city. Simply put, the elements of dedication of the easements were not met. For those of you who don't practice law on a regular basis, motions for summary judgment are only granted when there is no issue of material fact and the party requesting is entitled to a relief as a matter of law. In other words, the judge determined that there was no reason for a trial because the facts were clear that the Cantato easements were not public easements. Sorry, I think, okay. Based upon the doctrine of stare decisis, where courts are required to follow and uphold prior decisions, there is no reason to believe that there would be a different outcome of ruling with regard to these private easements in Cantato. The judge was clear. There is no mention of use of the bridle paths by the public or intention to dedicate the bridle paths to the city. It is the exact same facts in this instance, and one would expect the exact same outcome, that the easements are private. The plat maps do not support any other interpretation. Litigation is time-consuming, distracting from other important issues, and costly to the citizens of Cherry Hills Village. Third, the Cantato easements are not now and have never been public easements. The city's trails maps have never shown the 2 and 4 Cantato easements as public easements or as public trails. There are no recorded documents creating public easements in the public record. The 2 and 4 Cantato easements have never served as public access to the Highline Canal, and the plat maps are clear, including the corresponding declaration, that they only serve the residents of Cantato. It has been asked, why are the applicants pursuing the vacation process even though the easements are private easements? The reason why we are pursuing this is because the city asserted in litigation that these easements were in fact public easements. So now it has created a cloud on title of the residents in Cantato whether or not these easements are public or private, and it is confusing and something that must be disclosed in the sale of real estate on the standard property disclosure report. Although the litigation ruled against the city, vacation is the only path other than seeking a declaratory judgment and litigating the issue specifically for 2 and 4 Cantato. As a result, to clear up the record, the petitioner has submitted this petition to vacate pursuant to Cherry Hills Village Municipal Code, Article 5, Section 11510. The code specifically permits this type of petition, and petition for vacation is the appropriate process to remedy the prior claims that were made. Unfortunately, there are some other myths floating around out there related to these easements that I would like to correct. I would like to provide you with more accurate information regarding the Cantato easements. First, there has not been public use of the Cantato easements. The court filings made clear there is no demonstrated public use of any of the Cantato easements. Because there is no public use, there is no negative impact to the community of Cherry Hills Village to grant the vacation. There has never been public or private pedestrian access from Holly Street to the Highline along the southern edge of the Cantato subdivision. Even if one were to assume that these easements were public, there is no easement across 7 Cantato. Here's a picture for your reference. Leaving a break in the private easement path from Holly to the Highline. This makes such a path as a public easement impossible. So just to show you this is from the plat map, the land survey plat, and the area highlighted in yellow has no, on the original plat, has no bridle path easement along the bottom. And then here is a picture of what it looks like. And if you look at the area in front of the fire hydrant all of the way to the paved area, all of that area is not subject to any easement at all. whether bridle path or public or private easement at all. So there's a gap in the area, which you can see on your plat map. I'd also like to address the master plan. The master plan, unless adopted as part of the zoning code, is not obligatory and by statute is only binding if part of the code. Cherry Hills Village Code does not recommend or require the conversion of private property into public easement. The master plan is merely guidance for your consideration and is not in fact binding. Due to the confusion regarding the private nature of the easements, I want to take some time to outline additional factors that are related to the fact that the 2 and 4 Cantato easements are private easements. The 2 and 4 Cantato easements are private bridle path easements solely for the use and benefit of the owners of the Cantato subdivision. They are unambiguously shown on the plats as private easements with no public use. There was some confusion about what continues with the nature of the easements. The petition for vacation does not alter the private nature of the easements. They continue to be private easements exactly as shown on the plat map. There are no documents in the chain of title or claims from prior use that create public easements, other than the easements for utilities, which will not be altered. Everything on the plat map will stay exactly as it is. Finally, there are substantial additional reasons to vacate the 2 and 4 Cantato easements. The easements at issue are not part of a trail system that has ever been used by the public. They do not lead to a public trail, nor do they go anywhere. Rather, they are unconnected patches of land. They have never been improved or maintained to be utilized as bridle easements by the city of Cherry Hills Village. Simply put, the Cherry Hills Village has never treated the bridle path easements as part of their trail system. Additionally, from a practical standpoint, there is no parking that exists to support the existing public trail system, and no place exists to establish parking for use of either the existing public system or the Cantato easements. There is no land to provide parking in this area for the public use of the easements. There are only 2 ways to establish these easements as public easements. One is by common law. It is not possible for Cherry Hills Village to establish a common law theory of acceptance of the easements shown on the Lake Cantato plat or the Cantato plat. Cherry Hills Village conceded this in the prior litigation. The second is by dedication and acceptance by Cherry Hills Village. Cherry Hills Village previously conceded, also in the litigation, that the absence of any dedication or acceptance language on the Cantato plat resulted in a failure to establish any intent that the bridle paths were to be used by anyone other than the Cantato residents. The only dedication is to public utility easements for the perpetual use of the public utility companies. To conclude, the applicants, as the owner of 2 and 4 Cantato, have demonstrated that each of the criteria for the city to grant the vacation request have been met, and respectfully request that the Planning and Zoning Commission vote in favor of recommending to the City Council that the vacation request be granted. Given that the court has previously ruled that no one, including the city or the public at large, has an interest in the private bridle paths in Cantato, this is the prudent course of action for all involved and is clearly in the best interest of the city. Finally, it is part of the requirements for me to let you know what happens if the vacation is granted. Basically, the status quo will stay the same. The Theory O'Leary Trust, owners of 2 and 4 Cantato Lane, will continue to be the owners of the land encumbered by the vacated easement, subject to the private bridle path easements of Cantato and Lake Cantato. The existing utility easements will remain intact. The plat maps will continue to exist as recorded documents, and because the plat maps make no indication that the easements are public, the plat maps do not require any amendments. Finally, the access will remain the same, and the use will remain the same, as the public does not currently use the 2 and 4 Cantato easements or have access to 2 and 4 Cantato easement paths. I would like to turn it over to the applicant, Denise O'Leary, who will be speaking to you personally, since I'm just her counsel. So she personally wanted to speak with regards to the impact this has had on her. Thank you very much.
Thank you.
I can do whatever's easiest for you.
We'll let
Denise?
Denise speak, and then we can ask all three of you
Okay,
questions.
great, thank you.
Good evening, Mr. Chair and fellow commissioners. As noted, I'm Denise O'Leary, and I, together with my husband, Kent Theory, own the properties whose easements are in question. First of all, I apologize for Kent's absence. He has a severe ear infection that has affected his balance, making it impossible for him to walk. So I'm sorry he isn't here to be here for this meeting. The question before you has consumed many hours, and for us alone, over $100,000 of legal fees over a 4-year period. This doesn't include, of course, what the city has had to spend and what our neighbors have also spent. As you know, this issue eventually ended up in litigation and involved other Canito easements several years ago. And as Amy mentioned, the district court ruled unequivocally that these were private easements. In fact, ruled so decisively that this issue never even came to trial. I will also note, as has been noted, that the easements have access, parking, and connection issues that are all really quite complicated. I think they were just never meant to be part of the larger trail system. I will also just let you know that we have been big supporters of community open space in our philanthropy. We have supported urban parks with the Trust for Public Land. We have supported the Nature Conservancy. We have supported the efforts to develop the Highline Canal. I just mentioned that because we're not here to fight about whether or not this is, public, whether or not we want this in our area. It's just never been part of these two properties. Our ask is this: to apply the legal outcome that has already been established with the other Canito easements to ours. They are part of the same group as in the litigation. We just think this is the fair thing to do and hope that you will agree that the protection of private property rights is in the best interest of all Cherry Hills Village citizens. I thank you for your time, and I certainly thank you for your service to our community.
Thank you. We'll open it up to questions. And is this on? It's not on? It is on. Can we do all three? Does it matter if we do it sort of randomly, or should we do it one at a time, or does it make any difference? It doesn't really make any difference. Okay, open it up for questions. Fellow commissioners.
I still have my question.
Thank you. And try, turn your mic on, and all you have to do is hit that little. There you go. Lights on.
Has there ever been a discussion of what you mean by private use under these circumstances? You have residents there who already have their lot and their homes and everything else. There'll be I was going to say substantial, but I don't have any idea of the exact amount of land that will be available, or whatever you want to call it, for private use. Because private isn't public once it's private. And public, even though it hasn't been nurtured to be public, I'm just wondering what the residents anticipate to be private use of that. That's a lot of land there still.
So there are 3 documents that are in the public record. There's the original plat of Canito. There are the covenants that were recorded in connection with that plat, and then there was a replat of a portion of Canito. The original plat and the covenants clearly outline the bridle path easement use in the covenants, that it's for the citizens of the 12 lots in Canito. And the private use currently is de minimis. There is some horse riding that goes on within the subdivision, but the private use is not substantial. The trails have not been maintained either for public or private use, and the covenants do not compel the maintaining of the covenants or of the easements by a party. There's no HOA established, so there's no party that would be responsible for maintaining the private use of the easements. And it certainly is not a public function to enforce covenants that are of a private nature. Did I answer your question?
Somewhat, but you did answer the question, but I still wonder, that becomes private land, and that means...
Well, it's always been private land. It's never,
yes, but it has been
it's never been used by the public. There's never been, there are no public easements established by the chain of title, which is a normal way to establish a public easement. Normally, if an easement is to be dedicated to the public, the plat map language is clear that there is a clear intent of public dedication and acceptance. And you have to have both of those elements. You have to have dedication by the person and acceptance by the municipality. And the reason why you have to have acceptance by the municipality is that municipalities do not necessarily want all easements to be publicly dedicated. They may not want to maintain certain roads as public roads when they're intended to be private. And so those are the two elements to establish easements by plat maps, neither of which was on either the original plat of Cantato or the Lake Cantato plat. They're both missing the two requirements of dedication and acceptance. That's the only way you can establish public easements on a plat map. And the second way is to establish by common law, and the common law is only established also through intent and through use.
So can I jump in here? I think you are saying that the easements continue as private easements, which would be all the residents of that neighborhood.
That's correct,
But not
yes.
people outside of that neighborhood. Dora, you don't look satisfied.
Well, to be honest, and we're all in a group that wants to get this resolved, I keep thinking with that, there'll be land available, and if someone decides, gee, I really need a bigger shed to keep my equipment in, and I could put all these trees around it so nobody will see it that much, but the easement suddenly becomes used by those who really could use the extra development space. I was just at a...
The land actually can't be developed because there's public utility easements on top of it, so the land can't be developed. The public utility easements remain the same as they are.
Ah, okay.
There are, in fact, the public utility easements were dedicated and accepted in the plat language, and, sorry, I can go. I don't know if you have this in your packet, but if you look at the bottom area that's shaded along the bottom, that is both a private bridle path easement and a public utility easement. And so that will all continue to remain as a public utility easement. So nothing can actually be built on top of it. That can't be removable. So like you could have a fence or something, but you can't put an improvement.
Okay, thank you.
I have a question while you're standing there. You talked about a cloud on title and the need to clear that up. And I think you touched on this, but can you tell us specifically why a quiet title action wasn't appropriate? Because from my perspective, it seems way less expensive, less contentious, and it doesn't involve everybody in Cherry Hills Village.
The quiet title action would have actually required all of the people in the Cantato subdivision to be a part of it. And it would actually involve great expense for the city of Cherry Hills Village because you would be one of the defendants and you would have to defend it. We just did not think it was an appropriate route to go when you clearly have this available as part of your code that easements can be vacated.
Other questions?
Oh, sorry, can I add one more thing to that? The court also ruled in the previous litigation that the declaratory judgment was the appropriate action to take in light of this particular circumstance. So that was, in the previous litigation, it was a declaratory judgment action, and that is the route that the applicants would have to go if they wanted to go through litigation, not through a quiet title action.
That was a ruling from a lower court that could be appealed. And my understanding is it was not appealed. I don't know what the reasons were, but I guess I don't consider that determination to be fully conclusive of all the facts involved in the case here.
So the city elected not to appeal the decision. I don't know why. You could ask the city, but the ruling by the judge was clear that there was no mistake of, or there was no question of law left to be determined as applicable.
Mr. Lucas.
There's also a question down here. Hold on.
Map. So I just want to make clear, we're talking about this, which runs, I'm going to say north-south.
The area in red is the proposed vacation, yes.
Is it all the red or just the north-south running between 2 and 4?
It's all the red.
So did you ever consider going, you know, I assume that the city enjoys its bridle pass. And by the way, for some clarification, there are a lot of bridle paths that are incomplete. And Parks, Trails, and Recreation and members of City Council frequently go around the city, meeting with property owners, asking a session of the bridle path that might not be open. So your situation is not unique at all, and it exists throughout here. So, sorry for that. Am I back on? And a few other things I take issue with. Bridle paths don't have to have parking. And in fact, we would encourage no parking. It's a way to move. But I wonder, did you ever consider going to your neighbors and thinking about, rather than fighting through litigation, talking to them about a solution of if we vacate, and I understand you bought one property, number 4, at one time, and then number 2, and you've got an easement running through that. And I understand why you might not want that. That makes sense from an ownership standpoint. But did you ever consider, from being a good citizen and a member of the community and thinking about how bridle paths work and how important they are, maybe talking to your neighbors and extending one of these that run east-west as opposed to just wiping them all out?
So
and going to and threatening or litigating.
We have actually worked extensively with the neighbors since 2017. In fact, most of them submitted letters in support of vacating these easements. So we have been working on this issue with the city since it was raised initially. And the bridle path easements issue, the use is also for pedestrian. It's not just for horse in the Cherry Hills Village Code, so it's not limited to horse use.
Well, I'm just looking at the way this goes from the canal, and if you go back and you look at some of the writings and the history of the city, and there was a woman who talked very extensively about this, named Merle Chambers, and her involvement in trying to connect Holly to the Highline Canal.
Right, and I understand that, but you cannot get there because if you look at this, there's this gap right here at the bottom of 7 Cantito Lane. There is no public easement, there's no bridle path easement, there's no easement at all in the area shown in yellow. So the only way you could have one from Holly to the Highline would be to condemn that property. So there's no natural path to have an easement from Holly to the Highline.
And the applicant is not willing to help or facilitate that.
Well, it's not, it's on 7 Cantito, so it's unrelated to the applicant's property. The gap is on 7 Cantito, it's on the neighboring property.
Oh, I completely
And it
understand
extends
that.
all the way across.
I completely understand that. I'm talking about neighbors working with neighbors for the betterment of the city. And I look at this, and you have got a closed private community. You've got a sign on your road that's very clear it's private, keep out, and it's like your compound. And I don't think that's really where the city's coming from. And I have to tell you, when I look at what we're trying to promote, whether it's the master plan, which is not set in policy, or it doesn't dictate, and I understand that, but if you look at what the city's all about, it's open space, it's the ability to walk on bridle paths, get from point A. We talked about it back in 1964, and in fact, I'd like to share a map with everybody. So I copied this out of Clisina's book. And what's the name of it? I'll pass those out. High on Country, yeah. And it's the history of Cherry Hills, and it's in the back. And in this, I found it was interesting because in her book, she makes reference, I think this is a 1964 map. Maybe it's 1970. I still have 1970, and you'll get a copy here. But the trails through your property are clearly indicated. So this goes back over 50 years.
So is that a recorded document?
No, it's not a recorded document.
Thank you.
I don't know that it is, but it's in a book, it's in a history book about the Cherry Hills Village. And I'm looking to that to really understand where did this come from. And my sense is, what happened was you bought these two properties because you know what? When they did buy the properties, I've looked at the title work, I've looked at the exceptions on Exhibit B to all title listings, and they bought it knowing, wow, there's an easement coming right through here. And there was no problem when they bought it. Now, when they combined the properties, I suspect they thought, okay, this is something we don't like. And I understand that north-south. That makes sense to me because they own both properties. But I'm struggled with giving up something without getting something in return. And all I'm hearing is litigation rather than we'll go talk to our neighbors. Or maybe we can do something else. There's some give and take, and I don't see that.
So
I see it as a zero-sum game, to be quite honest.
The issue is that on the B2 exceptions, the easements are not shown as public easements. They're shown as bridle path easements and public utility easements. So a common, reasonable reading of that document that shows up on the chain of title is that the easements are private. A common reading or a reasonable reading would not be to read that the easements were ever public. There's nothing in the chain of title, there's nothing in the recording statutes or in the chain of title in the recording. Colorado is a state that requires public notice and documents to be recorded to put people on notice of encumbrances on their property. This document from the history book is not part of the public record. No one would be on notice of this. It's not even a public document. And so anyone can assert anything in a history book that doesn't make it an accurate depiction, and that's why we have recording statutes in the state of Colorado to put the public on notice when they're purchasing property, what their property is subject to. These plat maps were very clear that they did not dedicate these easements to the public. It doesn't meet either the common law standard or the statutory standard. So there's a reasonable person would never believe that these easements were public easements. It wasn't until one of the owners who had a similar situation to this applied for a permit to build across two lots that there was any assertion by the city that these easements were public. Prior to that permit application, no one had any idea that there was any sort of thought that these easements were anything other than private.
When I read the history, and I understand you're being paid to argue from a legal standpoint, and I acknowledge that. Mm-hmm. But if you look at it from a historical standpoint and what has happened, that was not the intent. It clearly wasn't. And we can go back and forth, all night long, and I'm not going to do that and waste the time. But I think it's a matter of the philosophy and sort of the sense that you take to this easement, public, private, whatever, versus what was really intended when the city was created, when it was founded, and when you had people. And I understand you want to make changes. To me, I look at it and there's no middle ground. There's not a spirit of cooperation or trying to meet in the middle with the city and work things. And I'm disappointed in that when I see that.
So the city had the opportunity, when they signed the plat map, had they wanted those easements to be public, to have had required them to be dedicated and accepted by the city. So the intent of the city can only be known what was documented in the public records. So the intent of the city at the time was not that those were to be public. And I would also say that they have never been maintained by the public. So there's never been any intent that these easements be publicly used or maintained.
Well, as I've read this, I think actually the intent of the city was that they were going to be public in 1964. That's when I read the history. That's very clear to me. Now, did they not do the necessary steps to make it public? Perhaps they didn't. And perhaps over time things have changed. You're arguing from a legal standpoint, but I'm not buying the argument for a second when I read the history of the city of what was intended. It was clearly intended by this Merrill Chambers to make a connection point from the Highline Canal over to Holly. That was clear.
So that may have been her intent.
If they didn't paper it properly, shame on the 1964, governance then. But I think you're taking advantage of that. And you don't have to respond. I'm just giving you my opinion on that.
Mr. Chair, I'd like to make a comment if I could. Is that all right? Because I want to follow up on this.
Go ahead. Thank
Okay.
you, Earl.
Thank you. And some of the comments are not only for you, but I want them to get out there to the rest of the people in the village. And some of this, most of it's all been said, but I'm going to say some of it again. The first thing is one of the things in your application, as well as in the letters, not part of a viable trail system. No one uses the trails. Not being maintained by the city. No parking to support the trails. They don't have access to the Highline Canal. None of that is relevant other than with regard to evidence that the city accepted the trails. Other than that, they have no bearing at all on whether the city has actual rights. If the city has rights, it doesn't matter that they're not using those trails or whatever. It doesn't matter what happens with regard to that. We need to get that message out there, okay? The master plan has been pointed out here and by former Mayor Chrisman recognizes that the city has trails that are unconnected and instructs the city to have as an objective to attempt to seek out connectivity. Not to give it up, but to go the other way. Now, with that said, I understand that the applicant believes the city doesn't have any rights with regard to the trails in question. I understand that. And I understand there's a cloud on the title from your perspective. But you are asking us to vacate whatever rights we have. And as you said, you're doing it obviously because this is probably the most expeditious way. Maybe it's the cheapest way to get it done. I don't know. But the one thing that I do know is that the Canito plat and the Lake Canito plats are different. They are different with different sets of facts. And moreover, the litigation and the Maven litigation and the decision in that case do not have precedent with regard to any other issues. So I just want, and of course you know that as an attorney. But I got a few more things to say and then I'm going to want to comment, and it might even be better that Ms. O'Leary make the comment, because I don't want to hear a legal response. I want to hear a response to very similar to what Councilor Bill was talking about there. Because I too said, okay, either we have rights or we don't have rights. If we didn't have any, you don't have to get a vacation. If we do, then you could still come and get a vacation, but you'd come with consideration of some sort. You'd come and say, hey, we want to get rid of this. This is what we're willing to give up, or this is what we're willing to do to make that happen. Well, we didn't get a clarification of whether or not the city has rights or not. You're just coming and saying, hey, we want to do it, and we just want you guys to vacate it without any consideration at all. And as we said, the master plan instructs the city to protect its trails and improve their connectivity. The city's commissioners and councilors are the stewards of the city's resources and assets, and the ones charged with carrying out the goals and directions of the master plan, which, by the way, right, it's not binding. But at the end of the day, I don't want anybody running for city council or getting appointed to these commissions that is not going to be dedicated to our master plan. We take great pains, and we're going through that now, to find out what our citizens want for our community at large. And hopefully, our commissioners and councilors are dedicated to implementing that master plan. But you're asking us here, as these stewards, to simply ignore this and simply vacate whatever rights we might have without any consideration whatsoever. I'd like to hear a comment about what I've just said. And this isn't a legal situation. It is with regard to saying, hey, understanding that we are stewards of these assets and that there are these issues associated with it and that there could be rights associated with the city there at that point in time, why wasn't an approach taken saying, hey, we want to come to you and work something out as Commissioner Lucas was talking about?
So we actually tried that approach, and we started that approach in 2017 and didn't get anywhere. I've had multiple meetings with the city trying to negotiate a settlement agreement, and those talks went nowhere. So we instead pursued this vacation, and the statute or your code does not require or even consider that consideration be submitted as part of a request for a vacation. That's not part of the code. The other thing you commented on was the Lake Cantatou plat. The Lake Cantatou plat also lacks the dedication and acceptance language by the city of the easements that are platted thereon.
No, I understand that. And again, I'm coming at it from the standpoint of, and again, you're members of the community. Cherry Hills as a community, which is a rural community, we talk about that all the time, semi-rural, rural, what does it mean? We have trails, we have horses, etc. It is a community that has a character associated with it. We have residents that constantly are coming up and talking about, hey, I don't like this because it's going against the character, or I don't like that because it's going against the character, when it's broad. But when it comes individually, oftentimes the views change. And again, we're involved in a master plan process, and we're going to be going through this now. So this is kind of a hot topic with me. And so what I'm curious about is as a member of the community, presumably one who wants to be a member of the community at large, why wouldn't there be and come at a different approach to sit back and say, hey, we'd like you to consider this. This is what we're willing to do if you guys would vacate these trails. Why wouldn't that be sort of the broader collective community at large beneficial way to approach this?
So we actually tried that. There was a group of 4 to 6 neighbors that were working on this since 2017, even through the litigation and through the post-litigation, but we were never able to negotiate an agreement with the city. So
yeah, I was on council at that point in time, and I know that there were discussions going on, but they stopped after the Maven litigation, which was really only with regard to one easement.
They actually continued for at least a year, if not a year and a half afterwards, because I was involved with them. And we submitted several drafts of a settlement agreement. So this is sort of the last step that we have taken prior to going in a different direction.
Jay, could you comment on that?
Yeah,
from the city standpoint?
The question is irrespective of the Maven litigation. In other words, when that was put aside, were there still negotiations going on with the city that would have resolved these easements with some consideration being made to the city after Maven was decided?
I cannot speak to that. I was not involved in that. I know that there were talks. I don't know what those involved, if there was a money involved or a cost for the easements. I have no idea what was being talked about. I was not part of those negotiations. But if I remember, there were still talks going on between elected officials, the city's attorney, and the owners of this property. And all the properties, I believe, as a group. But that's my memory, and I was not involved. But yes, I do believe that's a true statement, that there were some type of talks going on after the Maven litigation.
We actually modeled our settlement agreement after the one that the city council approved in the the Maven litigation. I took that document, redrafted it, and we had 4 to 6 neighbors that were willing to participate in that. Don Bailey was critical in going back and forth. If I'm present, then the city attorney has to be present. But if we just have the neighbors working on it without attorneys, then the process can go in an easier manner. And Don Bailey was critical in working on that. And then he put his house up for sale, and some of the other things happened, like COVID, and the talks just sort of fell apart. And so we submitted this petition for vacation over a year ago.
When the talks fell apart, what were the outstanding issues at that time?
I don't have, if we can put the plat map up, I can sort of speak to it, but it had nothing to do with the applicant's property. It had to do with another property. Sorry, I don't,
I thought we were talking about negotiations regarding these particular easements.
Sorry?
I thought we were talking about the history of negotiating the resolution of these particular easements.
We were trying to work a global solution with the city. All of the people in Cantito who have these bridle path easements on their property. It wasn't just Kent and Denise that were working on it. The 7 Cantito was working on it. Some of the other neighbors in the subdivision, we were trying to work a global settlement so that this issue could be resolved for once and for all, and not continue to have clouds on people's title.
And I think that that's true. I mean, there were those discussions going on, but you said, and then they continued after Maven, and in fact, they continued based on the settlement agreement with Maven.
Mm-hmm.
Which I think at the end of the day was all legal mumbo jumbo and resulted in no consideration to the city. I'm not certain about that, but I think that's the case. So if you were therefore modeling it after that, I can see why probably the discussions stopped.
Sorry, I misspoke. I took that and used it as a form to start with sort of the parameters of the deal, right? And did the recitals and used that as a form of a starting place as a settlement agreement. Sorry if I was confusing on that.
Okay, yeah, no, I appreciate that. So I guess the question is, and that's what it's, are you willing to consider picking up that approach? Because I think that's the right approach, which is exactly what Commissioner Lucas was talking about. That is the right approach to take, whether it's just for this particular applicant, or if you want to do it on a more global basis, but you're here just to talk about yourself, so that's fine. And to take that approach to say, hey, we want to do this in a collegial manner, supportive of our community, and end up with a result that we want, but at the end of the day makes sense for the community at large, and puts the stewards of the city's resources in a position to be able to be supportive of what you want to accomplish.
So the only way to do it is to involve everyone. The applicant cannot change the nature of the plat. So the plat is pretty clear that the easements are not public. In order to modify the nature of the plat, it would require everyone to be involved. And I don't know that we have that. We are not in the position to facilitate that anymore.
I think that that's right, but I mean, could the city not just deal with well, that's what we're dealing with now. We're dealing with the vacation of those specific easements associated with the applicant's property. So why couldn't we pick up on discussions and deal just with that? And so it wouldn't be a global, it would be just specific with regard to the applicant's easements, the easements that we've been looking at.
So under the covenants, they don't have the ability to unilaterally change the nature of the public versus private easements. The covenants would have to be amended first to make them so that they are not exclusively private easements. I mean, the way real property law works is there has to be a chain of title in order to change rights vis-a-vis third parties. The applicant cannot unilaterally change the recorded covenants that affect this entire subdivision.
I get the sense it starts with the applicant and what's running through their property. Could the applicant not meet with the city manager and the mayor without lawyers and work that out. If they came to some sort of agreement, it seems to me you could avoid litigation. The applicant could take it back to their neighborhood. But it seems to me, is it not possible for the two primary principals, and I'm calling the principal of the city, the mayor, and I imagine the city manager, to meet
So
with the
we've tried
applicant?
that approach, and it was recommended that we need to do the vacation. The city
Who on
cannot
earth recommends
bind,
litigation?
the city cannot bind the city without going through a public hearing process, which is what we are doing now. And that's what this is. It's a public hearing process for people to have notice and comment. They cannot, without being a result of litigation, enter into a private settle agreement with us. It has to go through a public process, which is what we're doing. We can only follow the city's code.
I have a question for Jay, or maybe Chris, or maybe Paul, and that is, can you summarize what happened at PTRC and why they voted this down?
The easiest.
What were the reasons?
It's exactly the reasons that are being brought up here tonight. The same arguments and the same statements, in a nutshell. It was their same thoughts as we've heard from the commission tonight.
My reading of those minutes indicates that they didn't seem to care about the diagonal and the north, east-west, but they were focused on the southern easement.
That would be correct.
Okay. Thanks.
But again, back just to what you were talking about, though, and I understand that that's with regard to changing the language of the plat and whatever, you need everybody together. You're here asking for a vacation of whatever rights the city has. Why can't you work with the city in such a manner to say, we want it, that's what we want, and we're willing to talk to you about this type of consideration? However that might take place.
The code doesn't allow for that. The code has a very clear process of what can and cannot happen, and that's not part of it.
So, question for the city attorney, is that true? I mean, really, at the end of the day, my guess is that, yeah, it's probably not written that way in the code. I can't imagine that we don't have the ability to be able to work around that in some manner. And why I don't mean that by violating code, what I'm saying is that, hey, we're here and we're talking about, and yes, we're going to apply the code, vacate the easement, et cetera, but in addition, this is something else that's going to happen, whether it's as part of or separate to.
The code in section 11-530 does allow city council to impose reasonable conditions upon vacation of any right-of-way. So reasonableness is a key consideration there.
I mean, we do have the right to do that, to impose conditions, which,
Right.
hey, how are you going to just,
And that becomes part of the ordinance, and that becomes part of the public record. But we can't come to the city and ask for a quid pro quo. I mean, that would be perceived as bribery. I mean, that's just not the way the public process works. Citizens don't get to ask for a quid pro quo in that sort of manner.
well, they might not, but they do.
Well, I as a lawyer would not do that. That is just not within the means of the code. The code does not allow, like, oh, we come to you and propose something in lieu of this. I mean, that's just not the way the public process works. I think it would be in violation of the Colorado Open Records Act, among other statutes.
I have a question. If you look at the city's trail map, the connector to the High Line right now is called 4750.
Mm-hmm.
It it connects to a bridge that's only been there 10 years maybe, or less. And then it goes east, and then it goes south. The portion, I guess it might be the whole trail, 4750, that goes east-west. And then if you continued that, you could go over to Union Avenue. My question is Trail 4750 part of this same plat? Or how did that come into existence? I'm confused. Because it looks like that would have been the same platted easement that's along the south side of the property we're talking about.
Can you pull up it's part of the public materials. It's not part of my PowerPoint. The city.
My concern is if we vacate this, what's the implication on 4750?
Chair LeMaire, are you speaking of the Pond Road Trail that comes from?
4750, and it's right, it's the west end of this red line on the lower part of your screen.
So the lower part of that is actually a road. It's,
Oh, you're talking about the gap in there?
There's an existing trail connection to the bridge,
Yes.
and it looks like it's part of this red line.
No, it's actually south of the property line. That little,
On a different property?
it's on a different
than-
property in a different
In
subdivision.
other words, if this was vacated, it wouldn't affect
No,
4750.
it doesn't affect 4750 or that little piece of Union Avenue that's right below the red line.
Okay.
So that is the Fairfax,
that's all I wanted.
the Fairfax Trail.
Yeah, got it.
So I want to come back again to this, and I think this is what the city attorney was reading a minute ago. The city council may impose reasonable conditions upon the vacation of any right-of-way, including but not limited to the payment of consideration by the landowners receiving benefit from the vacation. Are you saying that our ordinance, that's not an appropriate ordinance, the provision of the ordinance?
no, it's completely appropriate for the city council as part of granting it to do that. It's inappropriate for us to come to you and propose a payment to grant an ordinance. That's what I'm saying is inappropriate. We can't go to the city and say, we'll give you $100,000 if you grant us an ordinance. That would be perceived as highly unethical.
We could recommend to the council.
Right. I mean, that's the thing, is we're recommending to the council.
Right,
what they
we're
do.
not here to negotiate. We're not negotiating.
No,
Right,
absolutely.
right,
Yeah,
no.
We're not, that's not, what we're talking about is the process, which again, going back to
Right.
what Commissioner Lucas said, the process of sitting down with the city, working through it, that would ultimately end up with the city council granting the vacation of the right-of-way with some sort of consideration by the landowners receiving the benefit. That's,
The city council is absolutely able to make that recommendation. We, as the applicant, cannot go to the city council without it being a public meeting and being part of the public process to do that. And I think it would be perceived as highly unethical to go to the city council and say, we are willing to give you a certain amount of money if you will grant our ordinance.
vacation. So then what are you saying then, that since it's part of, it's inappropriate, you think it's inappropriate to do that, that if in fact this body recommends that that's what council do and goes to you and you go in front of council and they sit back and go, great, let's get into some negotiations, let's work through it, then you're comfortable doing it?
Well, that's the way the ordinance is written.
So you would be comfortable doing that?
I can't meet with members of city council without it being deemed to be a public meeting.
No, I understand that. I understand that completely.
So like, it's,
But you could meet with city staff.
right, we could, but we can't propose, the ordinance requires the city council may impose consideration. It doesn't say the applicant proposed consideration, which is a completely
Yeah, okay, that,
different.
yeah, and I understand that, but, that's ultimately how negotiations work at the end of the day. And what would happen is the staff would come back and make a recommendation to council and say, here's what we're recommending that you do, council, based on our discussions with the applicant.
We have met with staff, which resulted in their recommendation to you tonight. I've had meetings before we submitted the application, so before it becomes a quasi-legislative action. But now that the applicant is pending, we can no longer do that because it's considered to, I can't be in violation of Cora or open meeting. I can't do that. I would lose my license to practice law.
He's a lawyer too, by the way.
I did want to just interject briefly, also mention section 11550A, which allows Planning and Zoning Commission in providing the recommendation to City Council on the proposed vacation to include where appropriate any conditions necessary or desirable to protect public health, safety, and welfare. And I also wanted to note that staff isn't recommending any conditions tonight.
Staff is not recommending conditions? Is that what you said?
That's correct.
Okay, thanks. I want to talk about the practicality of the trail system out here and what's important and what's not. We have, to me, this is really an issue of connecting the Highline Canal with Holly Street. There's two connectors in that area. The one to the north is the Pond Road extension. The one to the south is Shenango Avenue, and then to the north, and then to that little 4750 connector that we talked about, and that's a fairly new connection, by the way. I want to say within the last 10 years. Is that right, Jay? The new bridge.
It was actually about 20 years ago, but yeah.
20 years ago?
Yes.
Wow. 4750. So there's two decent connectors from Holly to the High Line. The extension of Union Avenue would be a third one in that area, and I think that's beneficial to the public. I question how important that is. It obviously can enhance the usability of the trail system. The more connectors, the better. The diagonal to the north, and then that north piece that goes over and hits the High Line, I don't see any public benefit to those two pieces at all. And I wonder what the rest of the commission thinks about that.
I agree with you. Chair, I would just remind you, I think because this is a public hearing, correct? This is not it's legislative, that's right, never mind.
I was almost out of line, but I wasn't.
I was out of line for interrupting you on being out.
No worries, thank you. That if people generally feel that way, we focus on that lower east-west connector and discuss the utility and the importance of that and who it would serve and issues related to that.
Is there any new building going on along Holly Street on the west side of the street? It seems to me the other day when I was driving up that there was...
I'm sorry, I can't hear you.
Yeah.
Oh, sorry. Oh, you have to do, okay. My question was, it looks to me like there's some new building on the west side of Holly, south of Quincy. And not just one, but two or three large homes are being put in there, right?
True.
Seemed to me.
True. Yeah.
So just south of 7 Cantito?
Yes.
There's a couple going in.
Yeah.
One was a tear down and a rebuild, and I think, yeah, there's one or two new ones in there.
Yeah.
So the only way you can get that from Holly to the Highland, though, you're going to have to condemn a portion of 7 Cantito.
Right.
You can see the break
Yeah.
right there
Yeah.
on the
I'm aware
map.
of
It's
that.
very clear that it's not, that you can't do it without condemning
Well,
part of its
if it's an
property.
important thing to the public, and the public has all but 5% of it, then it's easily condemned at that point. Is it not?
I don't know. I don't do condemnation, and Don Bailey doesn't own that parcel anymore, so.
I'm not suggesting that. I'm just saying the public objective here is, as Laura stated and exists in the master plan, is to enhance and develop the future of the trail system in the village. It's a work in progress. It's not something that is static and is not going to change. And that goes to the point that was made that if the trail's not used, then it's not a viable trail easement. And that doesn't make any sense because, and nor would it appear on a map, because if it's not used and not improved, why would it be on the map?
It doesn't appear on any of the maps.
I know, but why would it be on the map?
It doesn't.
That's my point. The maps are that big. They're designed for use by people using the trails. And if it's a dead end or it's unimproved, it wouldn't be put on the map. And it shouldn't be put on the map because it just confuses people.
So your maps are available online, and it's not on any of the maps.
Exactly. And I'm saying it shouldn't be on the maps because the maps are for public use for wayfinding.
Right.
And if it's unimproved, it's a hazard. If it dead ends, it's going to put people in somebody else's side yard or front yard where they shouldn't be until it's an official trail that's been improved.
My understanding is that the maps that are online show the easements the city of Cherry Hills Village believes to be public easements.
I think it shows what are usable trails because that's the purpose of the map, is to provide a guide to the
There
public.
definitely was quite a lot of issue in the litigation of other easements that are not on the trail system that were in confusion of whether they were public or private. This is not a unique issue to this property.
Any other comments from the commission?
I have my microphone on. I was just curious, you all were talking about the previous settlement statements that were never finalized but negotiated. Does the city have record of those that we could review?
Well, that's a great question. I think the primary folks involved with that from the city side were Jim Thorson, my predecessor, and Kathy, who's not here tonight. So we would probably, it's a good question. We would probably want to check in with Kathy. Unfortunately, she's not here tonight. But I'm sure she's
Actually, I actually think it was Linda, Kathy's partner, that was the primary.
Oh, was it Linda?
primary
Okay,
thing, yeah.
but they still work together, the good news?
Yeah.
Yeah. So I guess it's a long way of saying, I fully expect that they have multiple versions of what was discussed.
I asked because depending on where this conversation goes, it might be helpful to review. It sounded like it would be helpful to take a look at those. On behalf of planning and zoning, I think part of also what's going on is there's been a lot of transition.
Several other properties have turned over since that happened, and the group of neighbors that were working together to try and make that happen, the composition is completely different. And I don't know that you will have the same unity that was in place several years ago.
Understood, yeah.
And again, I think that that's probably true with regard to a global settlement with regard to the thing, but in this case, and what the chair was talking about with Commissioner Lucas was with regard to saying, okay, the northern and the diagonal, but what about the bottom? And then some sort of compromise to effect a vacation of two of those and then a confirmation of the bottom one. Is that kind of where you were going with that?
Yeah, I was thinking that, we can either approve or we can vote to not approve, which is what PTRC did. Or we could say we agree with the vacation of the diagonal and the north, and on the south easement, we'd like to send that to City Council with instructions to work with the applicant and explore the possibility that becomes a trail of some sort. I don't think there's any reason we can't do that.
I think that's entirely possible. The recommendation for that then would I'm just helping out with the logistics here, because when we get to a motion, if that's what the commission wants to do, it'd probably be helpful to make a motion to deny those portions, approve those portions with a recommendation for negotiation of conditions, specifically sub A, and whatever that number was. So you would probably want to cite that specific section of the code in your recommendation.
So did I hear you, City Manager, that you were saying, forget the current recommendation, we approve the vacation of 2 of the trails and then go on to I would disagree with that. I would sit back and say they're contingent upon working something out with the bottom trail.
What I was hearing you say was recommending denial of the northern trail and the diagonal, but then approval of the southern one. You could make it contingent upon a condition, but
it's the other way around, right? I mean, it's
approval of the vacation.
I'm sorry.
Of the
Yes.
2 north. Subject to.
Yes. Sorry.
subject to.
Right.
So in other words,
Yes.
we wouldn't end up with, well, it all depends on what city council does, but you wouldn't end up with saying, okay, so 2 trails are now gone, they're out of everything, and so now we're in litigation on the bottom trail. We would not want to end up in that situation.
Right.
So
I would
therefore-
agree with that. So
Right.
yes. So we're saying the same thing. I just reversed the yes, no, positive and negative.
Not unlike what's happening in our next issue.
Do you want to propose a motion, Earl?
Oh, wow. And if anybody else has got one,
He's also a professor at University of Denver.
no, that's not true. Okay, I haven't thought about this, but I mean, we recommend the vacation of, and I don't know what the titles are here, but you guys would fill that in, of the northern trail and the north-south trail, subject to the applicant and the city coming to agreement with regard to establishing an easement on the southern east-west bridle trail, or trail. Something to that effect.
City attorney, does that work?
Yes.
Okay. Okay, motion has been made.
We hear it again.
Okay.
I took notes if you want. Ethan, do you have?
The Planning and Zoning Commission recommends that the city approve the vacation of the city's interest, if any, in the, again, insert bridle path easement that runs east-west
On the north side.
on the north side and north-south on, in between 2 and 4 Canito, subject to the applicant and the city coming to agreement on establishing a new easement, new bridle path easement on the east-west portion of 2 and 4 Canito Lane. Public easement. Yeah.
Which still goes back to the issue, though, that it doesn't go through.
But then that's okay. I mean, you know, again, the city has a lot of things that don't connect. We would have to go work that out at that point in time with that property owner, and that might take some time or might be relatively easy.
So can I just comment on that? Because we can't do that, because we would have to get the permission of everyone in the subdivision to do that. We can't unilaterally amend the covenants. And the covenants are clear that these easements are private. So we can't unilaterally amend them that encumber the entire subdivision to make that public. So you're putting the applicant in a position that they won't be able to fulfill.
So you're saying that, and again, I'm not a property lawyer, so I'm a lawyer, but I'm not a property lawyer. You're saying that the applicant can't grant the city an easement over its property without getting permission from the rest of the property owners? I don't believe that.
Well, that's the way the covenants are drafted. The covenants are drafted that the easements are private, and to amend the covenants requires consent of, I can't remember the exact number, but it's probably 67%, because that's what the statute requires. So they can't unilaterally turn a private easement that affects their entire subdivision
Okay, so I have a
into
question on that.
public
How are they
easement.
unilaterally vacating an easement if they can't
Well, because
unilaterally
the
grant an
easements
easement?
currently are private that run with the land of the owners.
Right? So do you have
together.
all owners
They have an
consenting to
undivided
this?
interest together.
Do all owners consent to what you're trying to do?
We would have to obtain consent from the owners and amend the existing
To
covenants.
vacate and to create a new easement? Right, so, but you don't have their consent to vacate, so what are we even talking about vacating for?
Well, you don't need consent to vacate. We're taking the exact same position that's consistent with the covenants, that the easements are private and have always been private. We're not taking a position that's inconsistent with the covenants or with the plat. Both the plat and the covenants would have to be amended to change this.
Well,
which is-
I think the nature of the easement is exactly what's being disagreed upon here.
Also, how is this motion relevant to what your covenants are? This is
I'm sorry?
a recommendation of P and Z.
Oh, I'm just
City
commenting that we won't be able to do it.
Well, you would if you got the consent of the rest of the landowners, though, right?
I know that that's not possible.
Well, but it's possible. You may say it's impractical, but anyway.
But I guess, and by the way, everything you said, if I was listening to you objectively, I'd go, "Oh, okay, that makes sense. But obviously, you represent the applicant, you don't represent the city. I'm not a property attorney, and I'd want to find out whether that was held water or not, okay? Because the issue is, as I'm seeing at the end of the day, if there are covenants in Lake Canado and Canato that basically say, forget turning what is right now a private easement into a public easement. I'm talking about granting the city a new easement on the private portion of the land. Are you saying that the covenants in Canato and Lake Canato do not allow any of the property owners to grant easements on their land, not associated with the private easements?
So the way that it works is when you own an undivided interest in any real property interest, you can't unilaterally change that interest. So the easements, we cannot unilaterally change the nature of them from being private to public. It would be like you can't grant that area is outlined on the plat as being private easements. They're dedicated to
Right.
all of the owners in common as easements. The only way to change that bundle of sticks is to have all of the owners consent to changing the nature of those easements.
I get that, okay, and I don't want to get into whether this makes sense or not. So there's a 20-foot easement, that's a private easement, part of the covenants, et cetera, and it's a private. And what I'm asking is and you're saying that the applicant couldn't go 20 feet to the north of that and grant a new easement, you're saying they don't have the right to do that?
Outside of the easement area, I don't know the answer to that question.
My guess is there's probably something that can be done there at the end of the day. I don't know that that's practical, but somewhere here.
It doesn't matter in terms of what we're doing right
Yeah.
now. Anyway,
No,
we're going to make a recommendation to vacate the two north easements and instruct the city council to work with the applicant to try and create a public access through to the south.
Right, we're going
Period.
to vacate those easements subject to the city working out with him.
Yeah, well, we can make that as a recommendation.
Mr. Chair,
Yes, sir.
if I may, just for a moment, I just want to discuss, without discussing, the confidential memo that was provided by City Attorney Guckenberger to the Planning and Zoning Commission. I think you have another option in front of you, which is to direct staff, to continue the case and direct staff to do some additional research to bring you back some additional information on a potential condition like that. If you have that confidential memo, I would just point you to Section 5 as a potential reason why that might be the better path as opposed to attempting to construct a condition from the dais related to this. And I can't really get into it because it's confidential beyond that, so.
Right, no,
I agree with that.
Okay, so what is our motion? look.
Well, that's up to you. I'm just suggesting to you, based on the confidential memo that was provided to you, that
Right.
if you wish to make a motion to add conditions,
How about if,
that you instead instruct staff to research those potential
Okay.
conditions, and you
Okay.
tell us
Okay,
specifically, we would like to understand the implications of adding conditions that do the following, A, B, and C. And then we can bring you more thorough analysis that addresses those, both from a legal perspective and sort of an administrative perspective.
For example, you could provide us a better review of the covenants.
Help answer the question that Commissioner Holland has, but also understanding, adding conditions, how those may play out with the other issues identified in the confidential memo that were not addressed. They were not addressed in the confidential memo.
So we wouldn't actually make a motion. Or the motion would be to table it and put it back to staff for further information, right?
Or you could continue to a date specific.
yeah,
we could also make a motion recommending vacation of the two north easements, subject to, and then add language consistent with the attorney's memo, which I'm not sure what that would be. I don't have that memo in front of me. Can you pull it up? Are you looking at it?
I think the section I'm referring to would say that wouldn't be consistent with the information contained in the memo.
Also, I think if we're going to draft a motion with conditions, don't we want to
wanna
actually draft
avoid-
it and have it versus trying to piece it together, right? Because the motion is,
Consistent with the
Of
confidential
course,
memo.
we have to take action, though. I mean,
Yes.
we got to do something.
Yes.
Could we go into executive session with the attorney and see if we could craft some language? Okay, I'd like to make a motion, we go into executive session.
second.
All in favor? Aye.
Part of that motion should be to quote the sections of the code that allow.
Yes. I certainly. Let's not for now. Okay, yeah, if we need, pull me in. Yeah, if you need me. And then, you taking Sylvia though, right? Oh, yeah. Yeah, I was gonna say. I was like.
Yes, there is. Left and then right and then straight.
Left, right, straight.
If you need me to go, come over.
Now can I sit up there?
You can, but you have to leave once they come back,
Why?
because they're going to make a motion.
Oh, well, I thought they were already done by now.
Just 1 second.
You're killing me, sorry.
No, you're fine.
Some people actually look. Right?
Thank you.
You're killing me.
Oh, yeah. It's lowercase, then CHP uppercase.
Don't give me that.
It's the guess one. No, I hear you. I was not the one who changed the time. It was,
Didn't somebody email me at 5 o'clock was okay?
well, I know last year when COVID had just started, we discussed 5 and 5:30, and then as part of your guys' rules of procedure update,
Yeah.
it was discussed at 5 p.m. to make that official.
Is that why you're in the audience, because you came late? Yes.
Oh, I thought you
Some people work full-time.
I thought you were recused or something.
No.
Oh.
No, but I would have voted. Never mind. I just have to.
So I understand there's a separate recording for executive sessions, recording device.
I'm just gonna, because I got this one, so.
Is it being recorded now? Can I say any joke? Is it being recorded?
This meeting is being recorded, yeah, because it. And, yeah, you could just press the record button. Or just start it and it's. Yeah, when you're done. What? That's what part of what we're talking about tonight.
Open house, I'm not gonna be able to make an open house.
On the 29th?
Yeah, I'm gonna be in Texas, sorry.
Oh.
Sorry.
No, that's okay. Thanks for the heads up.
Part of what
You're
we're
welcome.
doing tonight is, speak now and get the survey out the door.
I can't. Let's just get it out.
I know. Well,
Get it out.
I'm just following everything.
Okay, if we pump out the survey, how much time before the surveys are closed, the time to fill it out?
Oh, that's however long we want.
Okay.
I think through October, at least.
You're killing me.
What, you want more time or less?
Yes, more.
Well, November.
We got fall break.
Yeah.
Yeah, the end of November would be perfect, because
Yeah,
I could
that's-
seriously
that's
hustle.
Yeah, that's fine. There's really no set rule for it.
I mean, I've been hustling.
Yeah.
Yeah, and
Cool.
it's going nowhere.
Yeah. You mean about the master plan don't go about? And people are like,
Yeah.
well.
It's like, man, why are you being so serious? I'm like, somebody's got to be serious around here, you know?
Well, it'll be out for a good long while.
Okay, at least November,
Yes.
so I can get the dog down.
That makes sense. What's the item after this one?
Oh, changing R2 to R3?
Yeah, it's a
R3
rezoning
Rezoning.
for HA Let's Drive.
Pretty easy one.
I don't know, I thought this one. Easy.
Are you with the rezoning?
Yeah.
Are you the owner?
Yes, Lynn and I.
I'm sorry?
Lynn and I. Lynn,
Okay.
Juan, and I. You're Paul, right?
I'm not Paul. Paul was sitting right next to me, but yes, that's who you've been working with.
Yeah.
You work downtown?
Are we gonna, we're next?
Yes, so,
You're going to the office these days?
Yeah.
so right now, we're here, we're doing
You too?
the application, we're discussing this timeline.
Well,
It's gonna be continued till next month. Yes, you're right. So essentially, you're
I'm
right.
gonna buy time with some people.
This shouldn't be any real big problem, should it?
Not that I.
Who says yes?
Technically, we're allowed
The
to.
city is the applicant.
Politically,
The ultimate decision is up to the commission, but us as the city
Okay.
is the applicant due to the past area.
Just trying to clean that up.
Correct, exactly.
Why the federal
But
government?
yes, that's the word.
And they could approve
They
it.
are, but for.
They don't table it.
Yeah, so they're actually, what they would do is they would recommend to city council, that would be approved, and then city council would then take action.
You're gonna fill out and stuff, so we don't have the luxury.
So,
And Paul will present all of
I mean, I go.
yeah, so,
God.
once we get to that agenda item,
Still have to
Paul's
go
gonna
through
do
it.
his presentation. That will be a public hearing, so public comment will be allowed, and then,
And then,
the commission will be able to ask questions of.
just get the rule.
Yeah, in this case, staff and applicant are the same. Yeah, but yes.
So I can go home.
Yeah.
I still have work to do.
Okay. All right, well, it's nice to meet you. I'm Ethan with the Community Development Department. Nice to meet you,
Charlie
Charlie.
Winston.
Yeah, if you have any other questions, because it sounds like you guys will be doing some work on your own shortly.
Yeah, we're not really changing,
Mhm.
the footprint's staying the same, we're just trying to clean up what we got.
Sure.
And,
I got to quite a
I don't know how to make it over that, but we're adding another car garage, we're adding a third car, but it goes into we're connecting the garage to the house.
Okay,
So the footprint really didn't change at all,
gotcha.
except for swimming pool in the backyard, which
Mhm.
there's no
Not necessarily problem.
Okay. Well, yeah, if you have any questions along the way, please reach out. So, you'll be going through Paul and I for that process too.
Yeah.
So.
Well, we came here when we had it under contract, and like, we're gonna do a little remodeling and see any problems. And Paul was, like, I don't foresee anything, and
Oh, it's.
then after he did his research, when we hired the architect, John.
Was it Madden?
No, what's the name that's coming? Yeah, I think it is.
They're all through here.
He is with Shelley.
Yeah, that's,
Are they educated and knowledgeable?
and then they came up with, oh shit, we got a problem, and, you know, it wasn't ever zoned properly when
It's better than going to some
other
suburbs.
owners, that the previous owner kicked out to the east just a little bit into the kitchen, I think in 2000 something.
Hey,
And
So that's,
I got hit in the street, man.
that's part of the issue.
Hit in the street.
see, it's going from an R2 trying to get an R3, but yeah.
Correct.
So
Doing whatever.
everything looks like an R3 except paperwork.
Right,
Still are.
Right, exactly. So, yeah, no, absolutely, so.
And all the neighbors in the neighborhood, you know, we met personally with them, and told after the sign was put up, they thought, oh shit, what are they doing, building apartments or what? But we told them what the plan was.
Okay.
Nobody has a problem, other than we just like to start getting it down.
Oh, I'm sure, yeah, absolutely, absolutely.
In fact, we're waiting on this.
Yep, this is step one,
Yeah.
so.
So hopefully this is,
Yeah, it depends on how long they're in executive session, when they come back, the discussion will continue.
yeah,
And then,
I don't guess I really need to be your lens in a way, or can choose a position.
oh, okay.
And, but, you know, I can't answer a lot of questions other than what Paul's already going to present.
Yeah, Paul has a presentation all ready to go.
What, solar?
Yeah.
This one's unique because, the city is also the applicant in this case.
Yeah.
Yeah. No, yeah, if you need anything else.
Okay, thank you, nice meeting you.
Yeah, nice to meet you too.
So,
You said you're going to Texas, what
Yes.
part?
I'm going to San Antonio.
Oh, that's too far south.
Why, where are you from, Midland?
No, Dallas.
Amarillo? Dallas?
Yeah,
No. No.
just north of Dallas. Actually, I'm closer to Oklahoma than I am Dallas.
Oh, you are?
Yeah.
Was it Texahoma? Is that where?
Texahoma is way up in the Panhandle,
Is it?
Yeah.
Well, which, okay.
from like Denton.
just north of them. I have a ranch there. And we have a house here, and so I'm trying to get it was a mistake. It should have been zoned a different way. He can tell you more about it.
Yeah, I mean, the information's in your package.
Yeah, I read it.
Yeah.
No brainer. So what do you rank, like what do you raise? I don't know anything about that.
Cutting horses and cattle.
Petting horses?
Cutting.
Cutting, what is that?
It's a discipline of the horse, like barrel racing and working
Oh,
horse.
yeah.
But you have a pen full of cattle, and one horse goes in and the term is cut one cow out, keep it from going back in the herd.
Why would you do that?
Well, in the old days, they'd have to do that, sort them out, sort one of them out, maybe that was sick, you know, to
okay.
rope it and give it a shot, or to brand it. And now it's been a competition in the American Quarter Horse Association
Wow, who knew?
for 60 years.
Okay,
So-
do you have mini horses? Because I love mini horses.
Mini horses,
Yeah.
like little horses. I have 2 miniature donkeys,
Oh my God.
Poncho
mini
and
horses
Taco.
Bite. They
No,
bite,
no, these are friendly. In fact, we leave the door open at the back of the house, and we let them in the yard sometimes, and they'll walk in, go eat, and then just kind of stand there. I had a donkey one time that would come in the house, and I swear to you, I just got in a big screen TV like that right there, and that damn donkey would come in and watch that, and I'd change the channel, and
Yeah.
I'd find a channel like there was animals.
Yeah, it's like Disney or something.
Yeah.
Yeah, like, yeah.
And
Nat Geo.
it'd sit there and then it'd just lay down on the floor and like,
Just watch TV?
yeah.
Yeah. I have Tibetan Mastiffs and they do that. They watch.
But it's about the same size as
Yes.
that kind of dog, yeah.
Well, that's why I'm going to Texas. I'm dropping off one of them for military training. 'cause
Oh,
she-
yeah?
Yeah.
I have
Needs to
a,
be broken.
I have a black Labrador that we brought from Texas about 1.5 years ago, and the last couple of days, let's see, Lynn left on Sunday, so what is that, Tuesday? So I'd say Friday, I could notice something wrong. This dog's 7 years old. Beautiful, British lab, blockhead. But he was having a hard time urinating. And normally he eats and pees on everything, you know. So I kept watching him, and you know, he lifted his leg up, and I'm like, yeah. So I'd take him for a walk, and you know, I was like, something's wrong. But he, you know, labs have such a
Is it
good.
his hips or what is it?
Well, labs have such a good attitude. They're not.
They're not
Yeah, you know, and if they could talk, they wouldn't tell you they're.
Yeah.
And his appetite, I mean, he'll eat whatever you put down. So Sunday morning I got up and I fed him, and he didn't eat. And I had a vet appointment on Tuesday today, and I thought, something's up. I got to take him to the vet. So I found this emergency place down on Hamden. Is that the street?
Yeah.
It's
Hamden and Santa Fe almost.
Yeah.
BCR. Yeah.
So $11,000 later.
I'm sorry?
$11,000 later, they operated on him, and he had 15 bladder stones that was clogging up his urinary tract. He's still in there. $11,000. I could have bought 5 more just like him for that. But
I know, but they wouldn't be him, so.
yeah. And Lynn, my wife, she just left on Sunday morning. She was going to the airport. I was taking him to the emergency room.
Back to Dallas.
She was going to Hawaii, actually. She's a physician and has a doctor's office clinic over there.
Oh, how nice. Really?
Yeah. See, well,
Really?
to listen to her, it's not nice because she.
Did you just hear us complain about how many hours we have put in? I would love to be in Hawaii.
You know, it's, I like it. When she was in med school, the guy that she was previously married to, he was from Hawaii, and they both became doctors and went back there to start their business. And anyway, the business worked, but the marriage failed, and so she bought him out and then moved to Denver. And she's got a couple other doctors that work for her there, but she likes to go over, you know, about every 6 weeks for a couple of days.
Wow, that's a lot of travel.
Yeah, get away from me, I guess.
It's not you personally,
and then, you know, we're scattered out, and then we have the ranch in Texas.
Hey, what's the best steakhouse in Dallas?
The best steakhouse?
Yeah.
Oh, I'd have to say Bob's Chop House.
Oh my God, I knew you would say that. Because I went to Bob's in San Antonio 5 times because it was that good.
Yeah, Bob's is probably the best.
It cost me
a
ton of money, but it was so good.
You eat there that much,
That
you spend as much as I did. Yeah, that big carrot. Yeah, and the pickles. I think they bring out a big pickle or something too. But that glazed carrot, you know, it's like.
So good. Yo, you gotta go.
What?
Bob's Chop House is probably the best steak I've ever had.
Bob, yeah.
They're in Texas.
I haven't been to Texas.
Isn't there one in San Francisco too?
Yeah, Bob started the one on Lemon Avenue in Dallas.
So good. And now I'm hungry. I didn't eat dinner, so we're gonna wrap these meetings up real quick. Where did they go?
There's I tell you what, the next time if you're ever in Dallas, go to Albernay's.
Do you know how long they'll be in there?
Albernay's.
Is it good?
Yeah, and Bob's is
Yeah, I know it's
actually,
okay.
once he expanded,
Yeah.
you know, he kind of lost
Well, I
a little
told
bit of
Denise she
quality.
should leave.
But they're still
Yeah, no,
top
that's
or
fine.
not,
So,
but Albernay actually
I
started
wish I could tell you, hey, here's the
he was the
No, it's okay. The last time they did this, it was on
and he
Zoom.
moved to Dallas,
That's why I
his
asked him
manager
for a
at
laptop.
Mom Dallas.
No, and
There are some benefits to doing Zoom, but this is a much better process.
Everybody
I had such a hard time.
can afford it, goes there, I mean,
it's
really-
nice to be in person.
I mean, the good thing about me being a Zoom is I can pull the documents when I need it.
Right.
Oh, yeah.
Okay. And I was like,
I
God,
know
this
you
is like the
mentioned
best
kind
thing.
of the plat.
You don't
Is
need
that-
anything
We
else
don't need it
except for that
anymore.
steak.
Okay.
Yeah, and they're
I
much
didn't know if it was a part of the pack materials.
It's a part of the package.
It is, okay.
Yeah.
Then they should have it.
They should have it.
No, we have.
But if there's anything
bought
that
a
I can
house
pull up,
recently.
yeah, please ask.
Okay.
Absolutely. So.
Thanks for your help. I appreciate it.
Yeah, no, absolutely. I will come try. Everybody's my friend.
It's,
That's what I'm here.
That's really nice room.
Thank you. Yeah, this building, we will draft in February 2019.
Yeah, and our next door neighbor, we had a cocktail party, one of the neighbors, there's only 12 houses on the street, but one of the neighbors, it's just,
Yeah.
renters are building.
Right.
And they want to,
I think the very first meeting I had.
we had moved in our house, I'm trying to get it, so we
Okay.
can start construction,
Like, when we were still
redoing.
trying to settle this.
And,
Okay.
but even
Before COVID.
Yeah,
neighbor
before
to,
Okay.
neighbor to
Do you
this
remember the
side
conference
is,
table?
We do, so it could have been, we have several conference rooms,
Oh,
so it could have been
okay.
one of those as well.
Okay.
and then this side is
No, that's
down in
nice.
Charles.
Yeah, thank you.
Yeah,
We're
so
enjoying
you
it.
worked with Chris and Jay.
Yeah, so Chris is city manager, Jay's public works director, and then Paul and I are directly under Chris in the community development.
I talked to him, so
Is
I
he
was
for
there
something
when
else?
they.
Paul?
Yeah,
There's a rezoning case right after you get started,
Oh.
so, and that's right,
His,
so.
in fact, when I go
That's
there,
what he's taking.
and he said,
What
what
was
was
that
that
restaurant
restaurant that we
that
started and we liked? You know,
property.
I guess they opened a restaurant that we had a name. But I was asking her, I said, you know, we're gonna be moving in the neighborhood, what restaurants do y'all like to go to?
If you were curious,
It's
it's all in
Shannon.
the package.
Well, the packet is so long, sometimes I get up in that part, that's oh my gosh.
It's not a
It's
good
not a good mom, Shannon used to be phenomenal.
Paul did some research,
Going back.
they want to do some potential.
I went back, and then she said,
Back in, I think it was early
Ruth,
80s.
Chris, they,
Yeah.
There was a.
which are one of those in
Yeah.
Alabama, and I'm like,
At the
okay.
time of
And then she
that
was,
rezoning
she was
case,
kind of, you know, one of those,
law
show
was
off
not supposed to be-
ladies.
That was us.
That's orders were down.
We're fixing it, and she goes managing
You know, the hell with it. I don't
which
know.
makes sense with
We're,
the
we're got our
structure,
own shit.
the review that
And
was
we
done.
stay at home all the time.
Original structure was.
And I said, okay, well, we're gonna be right next door to you. I said, we just got a whole
No,
gate
that's-
in the fence, and I'll be over at your house.
But we're
Dude, I don't
more
roll like
zoning.
Okay, Jen works, I work minimum wage, practically, I work minimum wage.
Yours is more.
Well,
Okay,
Yeah.
yeah.
But we support planning and zoning, so
In Dallas when I was.
they have more knowledge on it than.
This is
I don't
been
know, part
an
of
easier
it's just kind of
process.
like this area. Yeah.
I told him, sorry.
And,
Hopefully, because that, you said that was over Zoom, right?
Trailer
Yeah,
house.
hopefully the in-person aspect.
cause I pull up and
Well,
shit,
yeah,
I
it's like
put
this
some ranch, I have a horse trailer, I might have horses in it, and horses and shit.
There's nothing.
Yeah, on the street, and I'm like, you know, I am what I am. Kick me out of the.
Yeah, no, absolutely, like I said, if I can
They
help
would never
anything,
do
if I
that.
can something pulled up, I'll do the best.
They would
I
never
can.
do it. Thanks.
Thanks, Amy.
Well, wow.
Jennifer, did you need a granola bar?
George,
Do you have something to
Yeah, no,
eat?
it's a strange.
Do you
deal.
want-
Come here, do you want something to eat too?
Pull in this.
I'm okay,
street,
thanks.
Go down and.
Are you
No,
sure?
you're gonna need bread.
I don't have a bazillion granola bars.
So.
I'll take one.
There's probably,
Yeah,
No, I'll
yes.
call you.
So,
from,
I'll call.
where you pull
Yeah.
onto that street, there's probably 15
Lord.
I was
houses.
gonna say, if I get it.
And then, so he bought.
I literally ran from work to like here, and I'm like,
And then the government bought with one next to the Secret Service, but, you know, they still protect me.
Right.
And, you know, I'm sitting here listening to this, you know, you gotta get permits, they put a gate on that street.
Really?
So unless that you've got permission to go past that gate, and there's not a guard, it's a clicker gate. But Main Street, and, you know, I guess you probably have to have a background check when you buy a house on the guy.
Don't answer.
I always put everything to voicemail.
I was sitting there.
Crazy
listening to
people.
that's the number, that's a ride.
That's what I do.
It looks familiar, I'm like, should I answer this? I'm like, no,
Restaurant.
deep in thought.
Yeah.
And I was like, oh,
A lot of
No.
people.
oh my god, I was like, okay.
But then I'll leave a message.
They got seat.
Oh, darn it, you did.
They're big.
I try and save every single number of people who are hoping to call me back because I don't answer the phone on this side.
I recognize
And
that.
I'm calling you.
If
But I was there that one
Yeah,
day.
leave a
straight to
message.
the end.
Yeah.
I don't
He
know.
walks in with his
I had someone leave me a message. I was reading the minutes for Cherry Hills Village. I really liked hiring you to do something. And I'm like, I didn't even return the person's call. I'm like, I can't even imagine taking a position at Burke's right now.
Yeah. You know, 8-figure service guy, man, he wasn't, his dad.
So good.
Right.
But anyway, we were at that place that night, and, having dinner, you know, I'm not walking at it or anything, but, man, boom, that door flew open, go Secret Service guy,
I mean, based off of.
said something to him, and I mean,
But I'm still in here, not up there.
so they were having dinner on another couple weeks, pushed away. And left.
Did they nominate who's gonna be vice?
So that's something that's up.
Yeah, it's an emergency, she'd be gone.
When.
Okay, because I want out.
Okay, so, I was like, dang, see, it's my phone calls.
That was the night.
They're not gonna nominate me again. So,
Obama,
Well,
Bin Laden was killed. And they, Obama had, or the White House, I guess, called him.
I have bug
so,
And alerted.
like
That was
right?
I got home and I saw it on TV.
So it was kind of like you had to hide, lay low.
Yeah.
Yeah. Okay. Wow.
We're wearing them down slowly but surely.
It is.
Yeah, I like
I live there.
I like it. That's actually the prettiest birthday.
Yeah, I befriended these, this older couple, like the former.
We all here? Where's Dory?
She was in the little girl.
Bernie?
Yeah, oh, yeah, yeah.
Do we need her?
No.
Go check to make sure she's not in the
In the
hole.
middle of nowhere, like.
I just do it, because we're walking out anyway. It's procedural.
Meeting back in session. Housekeeping. I'm going to do a motion. It's better than the one I did before. I move to go into executive session under CRS section 24-6-402, 4B, for legal advice relating to a motion regarding the vacation of easements at 2 and 4 Canito Lane. I further move to reconvene the September 14th commission meeting at the conclusion of the executive session for purposes of considering subsequent agenda items and concluding the regular meeting. Do I have a second?
Second.
All in favor?
Aye.
Aye. Dory?
Aye.
Pass. Roll call vote, isn't it?
We're leaving again.
Back to the same room?
Let's do a roll call.
Roll call vote? Is that what you mean?
Yeah, let's do a roll call vote for the executive session.
Roll call vote, Ethan?
Holland?
Aye.
Kaplan?
Aye.
Lemaire?
Aye.
Lucas?
Aye.
Miles?
Aye.
Miller and Wyman are not voting. The motion carries and you're good to go.
We just had to clean up the motion to go into executive session, so we redid that. We're gonna go back out and come right back in.
Of course, when I go to the bathroom, I miss the whole thing.
Very exciting. There was roll call, and then they left. That's all that happened. That's all that happened, so if there's something meaningful in that, you got me. Now are they doing, what are they?
Now coming back
Oh.
because they had their executive session.
They're just
That's-
correcting their motion to go into executive session.
Correct.
Do you think it's cold in here?
I work with, no. You have, what, oh, I can't even recognize you with that bottle of water.
It's in my purse.
Oh, okay.
Yeah, you're right, I don't go anywhere without water.
It's like here's the water.
My kids have gotten me into these hydro flask things.
Oh, yeah.
They keeps the water cold in my car and I love them.
Oh, yeah, because you like it cold.
Yeah.
You like
And
ice?
it keeps them cold a long time.
It does.
Which one?
Hydro flasks.
So hydro
Really?
flasks, yeah.
Where do you buy them?
Like REI, or I think they even, they have them at a lot of stores.
All
They're
questions.
expensive, they're not cheap.
Yeah, all questions of hydrating, you just ask me.
I do, I don't drink enough water.
Yeah, well, this lady causes headaches, so you should drink
Yeah,
water.
I know, and other things.
Yeah.
Yeah, yeah.
Well, I'm convinced, even though my retina doctor doesn't support this, I'm convinced that hydration in the heat this summer
Yes.
caused my retina tear.
Oh, I completely.
Who's your
believe
retina
it.
doctor?
You're on.
Ethan, how are you?
Good, how are you?
Dr.
Good,
Adam.
thanks.
That's his name. It looks like Adam, but it's Adam.
And he's
Oh.
local, right? The one-
What?
He's the one in Lowry.
Yeah, he's the retina doctor in Lowry.
Okay, there's another female doctor, she's Eastern European, who's really good too.
Yeah, I mean, this guy's great. They may be in the same practice. But I said, you know, I can remember I was in Seattle, you know, it's not supposed to get hot. And it was like 104, and I was working in the garden, and I wasn't hydrating enough, and I remember kind of getting a headache.
Whoa.
And then that night was when I started seeing the flashes, which indicated retina tear. And
The floaties.
the floaties.
Yeah,
Which,
yeah.
you know, they never go away. Once you have them, they
Okay,
dissolve.
is your retina completely detached or just torn?
It was torn.
Oh, well, you're lucky.
Yeah.
You don't want it detached.
No, my husband's had it.
That's
detached.
nasty, they put that.
And then you have to
that
shake
thing
your
in-
head like this.
Yeah, and your eyeball,
Yeah.
puts gas in it, it's disgusting.
It was just torn, and it wasn't a bad tear.
Well, good.
But now, and then another day, I was working with the horses, and it was really hot. And I realized I was getting dehydrated, and I also realized that I was getting an ache from my eyes. And I went, uh-oh.
Okay, yeah,
So I'm convinced that even though he didn't seem to think that would be a cause,
yeah.
he-
Amy, give her one of your bottles. Go on.
Oh,
Ten in your
do you want
car.
some of my water?
Give her one of your.
I don't keep these.
Do
in
we
my
have
fridge.
bottled water?
Oh, yeah, I need snacks. Does somebody need water?
I didn't mind having a water.
Yeah, I would love one too. Ethan, I'm so sorry.
No,
I love
you're good.
you.
I have extra sitting up here, so.
Oh, thank you.
Yeah.
Thank you. Just throw it.
And then actually,
My
can I have
face.
you sign some minutes from when you,
Sign?
yeah, since you ran the meeting?
Oh. Did I?
It was,
It was like 100 years ago.
you
Yeah,
remember that sketch?
I recognize you from somewhere.
Me?
Yeah. What's your last name?
Miller?
I
Do you know Andrea Kuser? Mohammed. Were you at the Human Trafficking Foundation?
No.
I was there, I was trying to think of the 2 weeks, but were you at the Women's of Commerce Award Ceremony?
No.
Okay, then where do I know you?
I don't know.
Okay, so are you doing anything with the Afghan refugees?
Who, me? No, I'm doing human trafficking for Eastern Europeans right now.
Who do I,
Pro bono, by the way.
good for you,
Yes, please.
who do I reach on that?
The Hopkins.
Thank you.
Yeah, because there were 14 women judges trained in Vermont. And I don't know how many of them got out. Any who didn't get out are dead.
Yeah.
But I'm more than happy to take one of these women judges. And
You should do it.
yeah, but I can't, I contacted the lady in Vermont, and I haven't heard back, but she's probably been scrambling. And probably, my email probably went into spam, because probably most of the emails she gets are not nice. And I just don't know how to get hold of her. And I have a whole bunch of furniture, dishes, pots and pans for the refugees. But I can't find out who will take them.
Okay,
And
then
we're
yeah.
talking like almost brand new furniture, almost brand new pots. Some of my dishes are still in the box, I just don't like them.
Okay, well, that's not a bad problem to have. So let me reach out to my girl and see if she could help me out with some Afghan refugees, maybe locally, if she knows of any, and
And I like
then
to
we'll
just
set that
get,
up.
they're getting apartments and stuff.
We'll set it up. It's not like I don't have anything else to do, but we'll totally
it's not a hurry, because apparently it's gonna take another 60 to 90 days to get most of these people out of the military compound.
Lovely, lovely.
So, or some of them may be there for over a year.
Well, it's just disappointing overall.
Yes.
Yeah. So, okay. I'll keep in touch. I'll text you, or I'll
Yeah,
call
well,
you.
you're seeing me around these meetings
I'll call you.
anyway.
I'll be like, hey, I
Yeah,
got your
it's not a big
contact,
hurry.
local.
Not a
Let's
big hurry.
Pick
We're
up your
doing
shit
this.
and drop it off.
Yeah.
Okay.
You just need to, because I had somebody working on it and they got me donation centers, but those aren't refugee centers.
No, they're not. They're not. No, I agree. I agree.
Also, the donation centers, then turn around and sell them.
They do.
Yeah, they do.
They do. They do. Okay, where would I know? Did you go to Creek? No.
No. Are you from Colorado?
Not really.
Oh.
Did you go to?
I went to sea law school.
Okay. No. No oil and gas.
And
no?
I used to work with Laura Brownstein.
You did?
Uh-huh.
Okay, I never worked at Brownstein.
You do oil and gas work?
I do for the Department of Interior.
Oh, that's awesome.
I represent the Secretary of Interior. I'm one of hundreds, okay? I'm nothing special.
You represent?
Deb
the
Hall?
movement?
Yeah.
Oh,
I do.
that is so cool.
I know, it's so dope. I'm not gonna lie, it's totally dope.
Oh,
She was on the cover of Vogue or a fashion magazine. She's pretty badass, I'm not gonna lie.
Oh, that is
Yeah.
way cool.
So what are you doing here?
Here, I'm just witnessing this.
No.
No, I'm actually lice.
She just got here late.
I just got here late.
Oh, okay.
Some people have work. So, no, yeah, but no, Deb Holland is amazing.
Oh, I can't even tell you. If there's any time that she's coming to speak or anything,
Yeah.
I would love to go.
She's gonna, well, nobody's at the Federal Center right now, but next time she comes, I'll invite you.
I would love to
So
go.
why aren't you in that room? Because you weren't part of this
Because
earlier?
when the meeting was called, I wasn't here, so I can't just insert myself.
Gotcha.
Yeah.
Oh, I didn't know that. I'm just so
I know.
excited.
So we're doing a lot of Indian work now, and we're really revamping everything.
I work with the Lakota up in Pine Ridge, but their charity is called Tiki Raisers. It's in Lakewood.
Yeah.
And so I can't even tell you how excited I was when she was made
Yeah.
Secretary of Interior.
Oh, we were pumped. We're like, oh, it's gonna be good.
She was the first woman to hold that position, isn't she?
No,
First Native
Gail
American. Well, no, she wasn't. There
Gail
is.
Norton was Secretary of Interior.
Yep.
Oh, you're right.
But she's the first Native American.
Yeah.
And the BIA.
To hold any
Yeah.
cabinet level position, I think.
And the BIA is under the Secretary of Interior.
Correct.
And the BIA has not well represented tribal interests.
Right.
Oh my God, the BIA
Is
is
that a nice way to say that?
I do their cases too. And I'm like, is anyone home? Anyone home? It's a hot mess.
It's a disaster.
It
Because I
is.
used to have to do, from a legal standpoint, I used to want to do like bonds for some of these tribal nations.
Mm-hmm.
And.
You did?
Mhm.
Oh, I'm dealing with something like that now.
I did, I worked on one up in Minnesota.
Okay.
So I learned that wild rice is not rice.
I didn't know that.
They get it off the lakes in Minnesota.
I didn't know that.
But it's not rice, it's a different,
What is
it's
it?
called wild rice. It is a grain, and it grows in the wild, but it's not rice.
It's something else.
It's something else. And then I learned that working on my bonds. I don't know why, but, and then I worked with the Hickoryas.
Yes. Yes.
And,
Yes.
that was interesting, and I was again representing lenders.
Yeah.
That was interesting. And then completely separate from that, I'm working with charities that are basically the entire board of Lakota. So it is, this is.
Absolutely.
So I work through them and I have lots of ideas and I get the biggest kick out of it because of no.
Yeah.
You know, nice, no. But I love it.
I do too.
I just love
I have a huge case with the Shoshone Wind River. Huge. We deal with the Navajo, nonstop, Ute. Osage is trying to get back in. It's just a lot of movement.
Oh, yeah.
Movement that we haven't, that we should have addressed, but it was always pushed to the back burner, truly, so
And,
it's
you know,
gonna
Pine
be.
Ridge is just a disaster. It's the poorest reservation in the country.
Which one?
Pine Ridge in South Dakota.
Oh,
And it has the highest infant mortality rate in the Western Hemisphere.
it's terrible. Laura, I just go home and I get the money.
Yeah.
They send me in to get the money. And that's what I do.
I mean, it's just amazing. But the Lakota, and there's a bunch of, you know, the Sioux, and
Yeah.
all the Dakota, the Lakota, and the Rose Lakota, Pine Ridge Lakota. They all don't get along. And, but since I've been working with them, they invited me, this was before COVID, they invited me on the Crazy Horse Memorial Ride out of Fort something in Nebraska. And I just did the first day, and that includes all the Sioux. So there were 250 riders.
Wow.
I was just gonna do the part of the first day. There were only 2 white people invited, and I was one.
Wow, that's cool, Laura.
And 250 riders, many of them are riding bareback. And the horses, they should have just called it the Crazy Horse Ride, because the horses flew crazy. And they put me on a horse that hadn't been ridden in 9 months.
How did that go?
Oh my God, I can't even tell you. It was very exciting. And but I'm the only person who's, of course, wearing a helmet.
A helmet?
I'm wearing my helmet. Especially I'm riding a horse I don't know, you know. And I was told that, you know, you have to be prepared for them to say all kinds of bizarre things to you, and, you know, because, you know, white people are not well liked. And that, you know, that they might actually like tap your shoulder, the kids would, to count poop and things like that. And none of that happened.
No.
Everyone was delightful. The only thing they would say is, as they would ride by, they'd go, "Nice cat."
No, I go to the tribes all the time. Navajo, Shoshone, Ute. What is it? The 3 affiliated tribes in North Dakota, because there's all that production, right?
North Dakota is what, the Crow?
The 3 affiliated
Blackfeet,
tribes.
the Crow, and some of the Sioux?
It's in Turtle Mountain. It's near Fort Berthoud or something like that. But we had to go up there too, and, you know, we write regulations. It's just it's never ending.
Oh, it's so interesting to me.
It is. It's fun.
That's a really interesting job you have.
Not really. It's pigeon.
Oh.
I mean, I don't know. And oil and gas is so hard to like learn in general.
I think it's really hard.
It is hard.
I hate reading oil and gas leases.
It sucks, I know. But I do offshore too, so, I mean, it's just a lot.
Wow, it is a lot. That is
It's a lot.
And this is a volunteer position, right?
Yeah.
Everything here in the city
everything
is volunteer
volunteer.
except for staff.
Yeah.
There are no,
Volunteer.
it used to be so funny because people would come up and say, "I pay your salary." And I'd go, "I want a raise."
Actually, you
From
don't.
0.
My salary is this. I want a raise.
Oh, man. I don't know. I'm just, tired. And then I got involved in politics, not because I wanted to, but because my girlfriend begged me to co-host this event, right, for the Cherry Creek School Board. And I'm like, look, I don't get into politics, okay? I don't want to do it. But you're one of my closest friends, so I will. So I'm done with it though, but I had to deal with that for the past month.
Well, and school board politics are hard pre-COVID.
Yeah.
I mean, it's insane. I'm like, you're running for a voluntary position on the school board? It was for Kristen Allen, and I did meet Jason Crow,
Jason Crow is awesome.
Yeah, he's a cutie. Cutie. And I love Army Rangers because I'm a military brat. So, I mean, I was like, yeah.
Oh, good, then I'll get you involved with my mounted patrol.
No, I'm tapped out. I'm overextended. But I love you. If you invite me to drink, I'll totally come over and pass out with you. Probably on your.
It's, I think at Dolores' house, she has the best patio.
She does. And I'm like, why? I could live out here.
Yeah,
you
I
wouldn't
could
even
too.
know. You wouldn't even know. Okay.
Is this like a judge? Do you stand when they come in the room?
No.
No?
What's wrong with Amy?
Well, you do in the courtroom.
Yeah.
Meeting resumed. Thanks for everybody's patience. Do we have a motion?
Yes, I move to continue this public meeting to October 12th at 5 p.m. and in the interim, instruct staff to investigate conditions related to the potential covenant conflicts and then possible consideration in accordance with section 11-550A of the city code for the vacation of any right-of-ways associated with 2 and 4 Canito Lane.
Thank you. Earl, do we have a second?
I second the motion.
Motion's been made and seconded. Do we have any comments?
I appreciate the motion. I'll be supportive of it, subject to what staff comes back with from a condition standpoint and really looking at, how does this make sense for our citizens and for the benefit of everybody?
Thank you. Any other comments? All in favor?
Is this voice vote or?
You can do a voice, but if you wish to do roll call, we can do that as well.
On the voice, if we can do voice, that's fine.
I think voice will do it. All in favor?
Aye.
Aye. All opposed? Motion passes.
Whack it hard.
Jennifer can join us now.
Oh,
Pleasure to have you here this evening.
Hi.
Okay, let's continue on. New business. Highline Canal update, as everybody may or may not know, has been rescheduled for next meeting in the interest of giving everybody enough time to do what we need to do. And this has taken a lot longer than what we thought. So that'll be on the agenda for October 12th. Then item C under new business is rezoning 8 Cherry Hills Drive from R2 to R3. And Paul Workman is our senior planner who will give us a presentation. Thank you, Paul.
Great, thank you. Can everybody hear me okay?
Yes.
You never know with these masks. Thank you, Mr. Chair, members of Planning and Zoning Commission. The City of Cherry Hills Village staff has brought this forth in order to correct an error in zoning that staff believes occurred in 1981. Note for the commission that the necessary public notification has been done, and staff received 2 phone calls related to this item. Neither phone call expressed support or opposition, they just were interested in more information. The subject property of this request is located south of Cherry Hills Drive. It's surrounded by other single-family detached residential homes, with the exception of the Cherry Hills Country Club to the south. It's currently zoned R2 and is just over 1 acre in size. The subject property was originally platted in 1937 as a part of the Cherry Hills Park subdivision, specifically Lot B. It was originally Lot 9 of this subdivision. That subdivision was approved when the property was located in unincorporated Adams County. Records indicate that a home was constructed on the shared property line between lots 9 and 10 sometime in 1940 or 1941, also while still in Arapahoe County. It was a part of the original incorporation of Cherry Hills Village and was originally assigned a zoning designation of R3. Property remained in this condition until the 1980s. In 1981, Mr. Foxley owned both lots 9 and 10, and in 1981, he was approved for the Foxley subdivision, and that was recorded in 1981 as well. Foxley subdivision shifted the shared property line between lots 9 and 10 of Block B of the Cherry Hills Park subdivision to the west. The previous property line is that red dashed line that's kind of in the center of the image there. Lot 1 of the Foxley subdivision was created as a 1.0046 acre lot and was undeveloped. That is the subject property for the hearing this evening. Lot 2 of the Foxley subdivision was created as a 2.69 acre lot that contained the entirety of the home that was built in the 1940s. That lot today is known as 9 Cherry Hills Drive. Both today and in 1981, 1 acre is and was the minimum lot size in the R3 zone district. As a result of this subdivision in 1981, the neighbors in the area expressed concern that other properties would be subdivided into smaller lots. These neighbors petitioned the city to initiate a rezoning to R2, which has a minimum lot size of 1.25 acres. And at the February 24th, 1981 Planning and Zoning Commission meeting, the commission approved a motion for the city to initiate a rezoning, and I emphasize, for properties set forth in the petition as presented. The petition that was presented was Exhibit F in your packets for this evening, and it states, "We, the undersigned owners of the property in the Cherry Hills Park subdivision, Block B, do hereby petition the City Council of the Cherry Hills Village to rezone the property of this subdivision except for lots 1, 2, 3, and 8 of the Cherry Hills Park subdivision, and, again, emphasis added, Lot 1 of the Foxley subdivision, a re-subdivision of lots 9 and 10 of the Cherry Hills Park subdivision, Block B, from R3 to R2. The map associated with this petition is the image on the screen, and Lot 1 of the Foxley subdivision is shown via the arrow from the blue box. The text on the petition that clearly excluded Lot 1 of the Foxley subdivision and the associated map clearly show that Lot 1 of the Foxley subdivision was not to be included in the rezoning. In April of 1981, the Planning and Zoning Commission heard the rezoning petition. The introduction of the topic at the meeting is consistent with the petition that was submitted, whereby Lot 1 of the Foxley subdivision is clearly excluded from the rezoning. That's the language at the top of the screen here that has the red underline. At that time, Commissioner Monroe made a motion to approve the rezoning and tried to state the lots that were included in the rezoning as opposed to those that were excluded. The motion was not consistent with the petition, and it's logical to assume that trying to identify the lots that were included as opposed to the lots that were excluded led to the confusion. This confusion and the obvious error to include Lot 1 of the Foxley subdivision rather than exclude the lot was carried forward to City Council. The first reading of the ordinance at Council was May 19th of 1981, just 4 months from the recording of the Foxley subdivision. At the hearing, Councilman Wellborn specifically asked staff if any lot would be rendered non-conforming under the proposed R2 zoning. Again, as a reminder, the R2 zone district has a minimum lot size of 1.25 acres. The subject property is just over 1 acre, so it would not have met the threshold for minimum lot size in this zone district. Staff replied that this specific item had been checked and that no lot would be non-conforming. If Lot 1 of the Foxley subdivision were meant to be included in the rezoning, it would become non-conforming as it does not meet the minimum lot size. The statement by staff at the time that no lot would be non-conforming is evidence that Lot 1 of the Foxley subdivision was not intended to be included in the rezoning, but was done so in obvious error based on the confusion during the motion made at the Planning and Zoning Commission meeting. The ordinance was approved by council on second reading at their June 2nd, 1981 meeting. In terms of formalities, when council rezones property, the legal instrument they use to do that is an ordinance. It's just the legal tool that officially rezones the property. In this case, ordinance number 5, Series 1981, references the petition that was submitted and clearly excluded Lot 1 of the Foxley subdivision. However, because the flawed motion at the Planning and Zoning Commission hearing included Lot 1 of the Foxley subdivision, the reference to Lot 1 of the Foxley subdivision being included in the rezoning was carried forward to City Council and approved by the rezoning ordinance. The inclusion of Lot 1 of the Foxley subdivision was an obvious error based on the petition that clearly excluded Lot 1 of the Foxley subdivision. This assertion from staff that the lot size were analyzed is evidence, as well as the statement that no lot would be made conforming, as well as the ordinance that was intended to rezone the property based on the petition and not the motion from Planning Commission. Additional evidence is in 1982, just 1 year after the property was obviously rezoned in error, a building permit was issued for the construction of the existing home on the property. The permit clearly notes the property is zoned R3, and it was reviewed under the R3 setback requirements. While the adopted ordinances are the representation of the true zoning of a property, the zoning map can be a visual representation of those ordinances, and they can often be helpful when trying to understand historical zoning in the community. The only zoning map that predates 1981 is dated 1970, was included in your packet, and shows the surrounding area as zoned R3. Staff was able to locate this zoning map from 1981. Staff would also like to note that the eastern boundary of Lot 1 of the Foxley subdivision is represented and coincides with the boundary of the R2 and R3 zone districts. This means that this map was created after council approval of the rezoning in June of 1981, and the map reflects the original petition that was submitted, whereby Lot 1 of the Foxley subdivision was not included in the petition to be rezoned. Staff was able to locate a zoning map from 1988 that reflects this same condition, and that was also included in your packet. Staff was unable to find a zoning map between the years of 1988 and 2008. However, the zoning map from 2008, as well as the current zoning map, show the property zoned R2, which is consistent with the ordinance that was approved by council. Please note that this map shows further visual evidence that Lot 1 of the Foxley subdivision, which is the smaller of the two lots, is zoned for larger lots, the 1.25 acres, and Lot 2 of the Foxley subdivision, the larger lot, is zoned for smaller lots with the minimum 1 acre threshold. Additionally, the lack of contiguity in the zoning in the surrounding lots, it is odd to have an R2 lot in between two R3 lots. So how did we discover this? Staff was contacted by the current property owner in the fall last year. They indicated a desire to purchase the property, inquired about making improvements to the property, and wanted to know what their requirements were. In researching the standards that were applicable to the improvements that the owner indicated, staff concluded that the lot did not meet the minimum lot size for a property in the R2 zone district, and that the home did not meet the setback requirements for the R2 zone district, but it appeared that the lot size and the lot location and the location of the structure would meet the requirements of the R3 zone district. The current requirements for the R3 zone district are the two red tables on the image in front of you. It's unusual for a property to fail to meet so many of the city's requirements, so staff assumed that there was history to this property. While the property owner was patiently waiting, staff researched old files and discovered the information in your packet this evening and the presentation, Based on this research, the rezoning was done in obvious error in 1981, and the rezoning is necessary in order to correct the zoning and for the R3 standards to apply to future building permits. The property owner has provided a letter of support that was included in your packet this evening. As a note for the commission, staff understands that the 1981 rezoning error may have implications related to 9 Cherry Hills Drive, which is the property directly to the east. Staff's currently trying to understand what, if any, impacts there are to that property, and if there are impacts, staff will reach out to that property owner and discuss what their options may be. Section 16-2-4B1 is the approval criteria for rezoning here in the village. B, C, and D are not applicable for this evening. However, A is. That states that if the existing zoning was implemented in an obvious error and the rezoning is necessary to correct the error, staff, through the information in your packet and the presentation this evening, contends that the rezoning was done in obvious error in 1981, and this rezoning is necessary in order to have the R3 standards apply and allow the property owner to submit and staff review and ultimately issue permits. With that, staff recommends that the Planning Commission recommend to council approval of the request by the Cherry Hills Village to rezone the property at 8 Cherry Hills Drive from R2 to R3 based upon the finding that the existing zoning was implemented in obvious error and that the rezoning is necessary to correct the error as set forth in the staff report and the evidence presented. That concludes staff's report. However, we are available for any questions you may have.
Thank you, Mr. Workman. Any questions of the commissioners? Okay, would somebody like to make the motion that? No, you've been sitting out in the audience. We want to pull you into the. Here.
Isn't this a public hearing?
Yes. Yeah, this is a, sorry, Chair. This is a public hearing, so I'm just going to go grab the roster to see if anybody did sign up for that public hearing.
Okay.
Okay.
Great.
And it might be advisable just to open it to see if anybody is here to speak who didn't get a chance to sign up. Open it for public hearing or public comment.
Open for public comment. And nobody signed up. Thank you. Close the public comment. Do I have a motion?
Yes, I move to recommend to City Council approval of the request by the City of Cherry Hills Village to rezone the property at 8 Cherry Hills Drive from R2 to R3 based upon the finding that the existing zoning was implemented in obvious error and that the rezoning is necessary to correct the error as set forth in the staff report and the evidence presented.
Second.
Motion's been made and seconded. Any comments, discussion? If not, we'll call for a vote. All in favor?
Aye.
Aye. All opposed? Motion carries. Okay, next section of our meeting here, I think we're going into our work session. Do we have any reports?
Sorry, Chair. Yeah, we have reports.
Okay, go ahead.
Or, I'm sorry, first, if there's any reports from you guys or any commissioners.
Any reports? Nope.
Just a quick update for me, and then Ethan has one. Earlier this summer, we discussed a series of housekeeping amendments to the land use regulations. Those have not been forgotten. We've been working with our legal team to draft language consistent, that's legal and consistent with the intent and feedback we got from you and City Council. We anticipate bringing those formally back to you for a recommendation at the October meeting. So,
Thank you.
Now we have 2 items on the October meeting.
Yep. And I think most people know, but the Highline Canal Conservancy presentation got rescheduled to October 12th as well. And as well, we will be electing a new chair and vice chair on October 12th.
Yes, so as previously discussed earlier this year, at next week, or not next week, next month's meeting, per our rules of procedure, we'll be electing a chair and vice chair. But us as staff, we did have the thought of holding that election after those agenda items to avoid confusion of procedure of the meeting. Sure. But we wanted to hear from commissioners as well.
Sounds good. Okay, city attorney, anything?
No report.
Thank you. With that, we move into our work session, and who's going to conduct that? Paul?
We have to adjourn the...
Yeah. Yeah. No,
we have to adjourn.
Yeah.
Meeting adjourned. I say it and then hit it, right?
Could I make one quick request?